Sir, I will not repeat myself. I will be repeat anything that
So
we
we are giving you 10 minutes, Professor Mohan Kumar. Mr. Khanna, 10 minutes to you, and this will then proceed. Please, sir.
Yes, I may take a few minutes more, sir, if I want to complete, but I'll only stick to 2 points. My central submission today, sir, is to address the question. Yes, let me hand over the written, sir. So my central point is to address one issue which has not received adequate attention, and that is the question of the demand for social justice from within the religious communities. We have been assuming that there is part 3 standing alone, and then there is 26 on the other side, and there is a battle only between these two provisions. This is not true, sir. We know that in the 19th century, there was a massive movement for social justice within the religion by various great saints who were born in about 25 of them across this country. And I stand here on behalf of an organization representing the work of Sri Narayana Guru, who is one of them, born in 1855, died in 1928. Now, what I want to submit, sir, is can space be given in the architecture of the right of religion, as it is now, inside the religion, for these forces also to be active, so that they can complement and supplement the part 3 ideas? This is the central argument, sir. I'll make one or two things. My central argument will be based on a very little noticed document.
Nobody can dispute that if the religious community or the people themselves or a particular religious denomination,
Yes, sir.
if they want to bring some perceived reform within themselves,
Yes, sir.
they have absolutely, even that right to my mind is also protected in 25 and 26.
But my submission,
if they want to reform,
yes, sir,
bring
my submission is,
but that will be their own voluntary decision.
yes, it
that
is.
They want to give up.
It is, sir. But I'm going to show you that the architecture of the right to religion of the Constitution has been interpreted in the last 75 years to silence these voices. And this reference is the first time in the history of this country that nine great judges are reflecting on religion conceptually, not deciding a case. And so this is a great opportunity for course correction. Recognize the need for some adjustments to the legal structure of the interpretation, not the Constitution, to provide space for this. Now, the best expression of this space, of this version, of this perspective, is a document submitted by Dr. B.R. Ambedkar to the Constituent Assembly, little known document, in August 1947, which is his proposal for the right to religion under the Constitution. He submitted it as a member of the Constituent Assembly to the Subcommittee on Fundamental Rights. Sir, if you may turn to page 19 of the written submissions, you will see this extraordinary document, sir, of Baba Sahib Ambedkar. These are 14, 15, 16, 17, 18, 19, 20 are his clauses on what should be the constitutional provisions on the right to freedom of religion. Let's look at 14, sir. The state shall guarantee to every Indian citizen liberty of conscience. No time, I won't get into the difference between freedom and liberty. Highest is liberty, what you're born with, liberty of conscience, and the free exercise of his religion, including the right to profess, to preach, and to convert, not practice. He did not include the word practice. Profess, preach, and to convert within limits compatible with public order and morality. Very crucial difference, sir, in the language. But the spirit behind this is an expression of the suffering and oppression of a very large number of people within that religion. There is that we accept the Constitution in its current words and language, but we must give space to this aspiration of freedom to convert, the freedom and to not allow practice to become the madhatipati of the clauses on freedom of religion. And the faith in God should not be replaced by faith in the clergy. That is what comes from this clause, sir. And second, no person shall be compelled to become a member of any religious association, submit to any religious instruction. This is the heart of the freedom of conscience, that I am not bound to obey the clergy. The clergy and I are equal. He can persuade me. I have respect for him. We all have respect for clergy. They're learned people. But they cannot compel us to submit to any religious instruction. And that religious instruction includes also the idea that someone cannot enter here, somebody cannot go there, or perform any act of religion. Subject to the foregoing provision, parents and guardians shall be entitled to determine the religious education of children up to the age of 16 years. No person shall incur any penalties of any kind whatsoever by reason of his caste, creed, or religion. Nor shall any person be permitted to refuse to fulfill any obligation of citizenship on the ground of caste, creed, or religion. And these penalties are the ones we've been discussing. The moving account of Madam Bhakti yesterday was an example of her having to suffer penalties because she was born a woman. The state shall not recognize any religion or state religion. Persons following a religion, 18, shall be guaranteed freedom of association, sir, and shall have, if they so desire, the right to call upon the state to pass legislation in terms approved by them, making them into a body corporate. So ensuring equality within the religion, that the devotee shall be equal to the clergy. They are all under 25(1) equal in their freedom of conscience and their right freely to profess, practice, and propagate religion. So the option of becoming a corporate body is given as a fundamental right. Then 19, every religious association shall be free to regulate and administer its affairs within the limits of the laws applicable to all. Within the limits of the law applicable to all. This is the aspiration of 80% of the people of this country, sir.
So, Gopal, please don't treat it like
Yes,
Article 25 or something.
This is
Yes,
the
sir.
original draft proposed by Dr. Ambedkar.
Sorry, sir, I can't.
We are on
That
the
was
interpretation of the Constitution.
debated, deliberated, then some revisions, revised versions came, and eventually what was approved was which Dr. Ambedkar very strongly advocated. Eventually, what is the final shape of the provision in the Constitution today is also a gift by Dr. Ambedkar only, because it was he who
Sir,
advocated.
Sir, I have no,
each and every word
just to save time, I have no quarrel with the current structure of the Constitution.
This was rejected, saying that it's a criminal offense.
Exactly.
Sir, no, this was presented to the, no, not to the Constituent Assembly, sir. It was presented to the Fundamental Rights Subcommittee. That's another issue you're raising, not this one. What I'm saying, sir, I'm not quarreling with the current structure, because the current structure represents a good compromise and is based, in my view, on three principles: that the state must protect religion.
But we can't go beyond the Constitution.
No, sir.
You are at liberty to interpret 25 and 26. We'll hear you on this.
Sir, I am
If you
saying
want
that.
us to legislate by your judicial
No, sir. I started by saying
Yes.
that we have to interpret the current structure of the Constitution in a way that accommodates these ideas. That's all I'm saying. Because the Constitution, as eventually adopted, has three fundamental pillars as I see it. One is you must protect religion. Second is, where religion can be a negative force for social justice, it must be regulated. And where necessary to reform, it must be reformed. These, in my view, are the three fundamental pillars of the current structure of the Constitution. The problem is with the interpretation, not with the structure of the Constitution. How we have brought in various ideas through interpretation that have stifled these ideas of democratization and social justice that come from inside religion, which must, in my view, be liberated from those difficulties. Then religious association shall be entitled, that I'm leaving, sir. Now, I want to say just another 2 minutes. I want to give you, on this point, a little less known background, and Mr. Dhawan will know more about this on this than I, more about this than I do. The origin of the clause that finally came into the draft Constitution was taken by Benegal Narasimha Rao, a very great scholar and bureaucrat, from the Irish Constitution. And the Irish Constitution at the time was an interesting model, because although in 1937 it had become a democracy, the theocracy had a very strong role in that Constitution. And this Article 26 provision was drawn basically from a theocratic model, where the Catholic Church was having a dominant role, controlling not only religion, but social and economic factors. The tension between democracy and theocracy was very much from the 1922 Constitution, 1937 Constitution of Ireland, very much in play. And therefore, there is need to adapt. Now that clause was adapted. For example, the Irish clause says freedom of religion and all freedom to manage all affairs without restricting it to religious affairs. Our constitution restricts it to religious affairs. We have introduced the words freely and equally. So the constitution took a moderate approach, neither this approach nor the Irish approach, but the importance of the clergy in Article 26 originates in the Catholic Irish constitution, almost exactly. And we must be aware of that. So we need to interpret 26 not consistently with the Catholic theocracy, but with our secular democracy, as when we interpret it. That's my second point, sir. And the third point is, sir, if you look at the main barriers that we have to 2 or 3 points, so then I'll end. If you'll permit me, I'll just have a drink of water. Sir, there are 2 or 3 points that are clogging this internal struggle for democracy, including Periyar and Narayana Guru and Jyotiba Phule and all these great people from coming into our jurisprudence. And that one of those, sir, is that there's a question, when you say religious denomination, madam, who represents a religion? Is it the Pulaya, Paraya, Irava, or is it only certain sections that are born into that, to that privilege? Who speaks for the religion? How is a religious denomination constituted? You said when you become a member of a religion, very correctly, madam, that you're subsumed into that religion. You're right. But many of us have not voluntarily joined a religion. How did we become Hindus? First, we were classified in the census as Hindus, as a residual category. And then, without asking us, and then in 1966, Justice Gajendra Gadkar in Shastri Yajnapurush decision said Hindu is one who accepts the Veda as the highest authority in all matters religious and theosophical. They didn't ask me. None of us said that. Now, I'm sure that I have the highest respect for Veda. I have great admiration for it. But is it a fact that all the people who are today classified as Hindu accept Veda as the highest authority in all matters spiritual and theosophical? So in this manner, sir, we were not subsumed into religion, we were consumed by religion. And so we have to also consider from a constitutional point of view, what is the choice? What is the agency?
This has nothing to do with Shabrimala.
No, please. What is the agency and choice?
We see nothing in Shabrimala. Counsel, please wait. Let him present.
This is not Sabrimala, sir. This is a reference on the right to freedom of religion. This is not a Sabrimala argument.
Listen and then.
And so, sir, we need, madam, to consider voluntariness.
This why, for as Hinduism is concerned,
Yes.
it
No.
is also called a way of life.
Yes, ma'am.
It is called a way of life. It is not necessary for a Hindu to go mandatorily to a temple
Right.
to perform a ritual. He or she still remains a Hindu.
If that
Even
comes,
though,
Yes.
because it is a way of life.
if that comes across in the reference judgment, that will be a huge
Yes.
relief.
You see,
Huge
that
relief.
is how it is.
And we have to
construed.
It
read.
is already there, you don't
Already-
require a judgment on it.
No,
People are,
It is
see,
integral
so
in the
many
religion.
people
no,
in
sir,
fact
I
do not
agree.
go to temples, do not have a place of or a shelf or room or whatever you may say in the house
Yes.
where they offer a veneration or puja. But even then, their psyche is such that they are Hindus.
So, ma'am,
It's a way of life.
I
People-
totally agree.
It need not be
lit-
ritualistic.
People will lit a lamp inside their hut
Yes.
and that's all their religion for them.
I totally agree, sir.
They don't require to
must-
go to any.
That
But
must be,
nobody can come in the way of people having their faith.
sir, article, ma'am.
No, but that, the viewpoint we give
Yes,
is very.
that's a point, sir. Madam, Article
Nobody
25,
can come in the way of people
yes,
having their faith.
yes. Ma'am, you are absolutely right. Article 25 protects that, but our jurisprudence does not. That's a problem. So through interpretation, we can look at that. I want to say, ma'am, that when we say that people have this freedom of religion in practice, what we actually practice is not polytheism, not monotheism. I call it autotheism. That each one of us decides, as Honorable Chief Justice rightly said, if I light a lamp in a little hut, that is my religion. So it's autotheism. I decide what is sacred to me and how do I pursue it. After all, conscience is the ability to explore the inner conscience and then come to some conclusions about how that understanding coming from that exploration should guide my action. That is very individual. There cannot be a group right. I would submit that there is no conflict between 26 and 25. The Tantri is exercising his freedom of conscience and the devotee is exercising her freedom of conscience. The difficult question is, how do you resolve it? And there I have in my material a reference to an American judgment which says that one principle to resolve that is, you cannot use your freedom of religion to deprive someone else of their civil liberty. Religion cannot be used to deprive them, someone else. I can impose a restriction on myself, but I cannot impose my freedom of conscience to take away civil liberty of others. I've provided, I'm not going to refer to it. So I just want to say that the last point I want to say, sir, Honorable Chief Justice, is that the definition of freedom of religion in Shirur Math slightly may need some adjustment for you to consider, like the definition of Hindu needs to be reconsidered in light of what Madam Justice Nagaratna has said, that it is truly open so that the jurisprudence, the practice, and the constitution can be aligned. But in terms of religion, there is a requirement to be part of organized religion, that you have to believe in established precepts and practices and rituals in order to be protected by Article 25. I think that should be given some leeway. It could be that, but it could be also autotheist, because 80% of the people of this country are autotheists. If I want my child to do well in an exam, I go to temples, I go to mosque, I go to church, I go to Gurudwara, and I come back home. My family will be very happy with me. You've gone to all the gods and prayed to all of them.
Dr. Mohan Gopal,
Yes, sir.
Shirur Math, in fact, goes a step ahead
Yes, sir.
and says that an atheist is also a part of the freedom of conscience.
Yes, sir. Yes.
So whether you talk of
non-believer
autotheism,
You can be a non-believer also.
whether you talk of autotheism,
Definitely, sir. But
monotheism,
even amongst believers, sir, ultimately, we respect the conscience of everyone, the priest as much as the devotee. And we have to find ways to resolve that. It's not a group right versus individual right. It's only 25 versus 25.
Shirur Math requires any tailoring.
Right, sir. No, I'm saying just on the definition of religion, sir. On the definition of religion.
That's what we
A
say.
little
Whatever you're
flexibility.
proposing to
My submission, sir. My submission. And I just want to conclude, sir, by saying if the opposite side agreement is accepted, any group can claim to be a religious denomination in this country at their own will, and thereby acquire the power to supersede Article 15 and Part 3, if I put it more strongly, to secede from Part 3 of the Constitution, with respect to anything they declare as a matter of religion, without any guardrails such as essentiality. In effect, this would be a gross misinterpretation of the right to freedom of religion in the Constitution. Faith in God versus faith in clergy is the real issue on which this court is being tested in these hearings. Please do not let faith in the clergy defeat faith in God originating in the individual conscience. Thank you very much for your time.
Thank you, Professor Gopal.
Thank you, sir.
Anna, please.
Please.
Let us not forget that Article 25(1) is also part of Part 3.
Yes, yes. Yes. Very much.
Yes, Mr. Khan.
I just pick up my things in 1 second. Thank you, sir. Thank you for allowing me.
I'm grateful to your lordship, my lord. My lord, insofar as, my lord, I have given my detailed submissions on all the issues.
You can
I will be only confining in my short note on the issue number 2 and 3, my lord. That is, my lord, the interplay between 25 and 26, and whether Article 26 is subject to the other provisions of the Constitution. My lord, the short note is in the file itself, my lord. Your lordship may just pick up my short note, my lord. And page 2, my lord. Lord, one aspect of the first issue I wanted, but I am giving up because of the paucity of time. I'll straight come, my lord, to the issue number 2 and 3 at page 2 bottom. As you said. My lord, my respectful submission is, my lord, the Article 26 is an enabling collective right. It is submitted that Article 26 is essential character, is an enabling provision in contradistinction to the declaratory character of Article 25. The enabling nature of the right is implicit from the text of 26, which uses the word shall have the right, whereas, my lord, in Article 25, what words used are entitled to freedom. So, my lord, that is the enabling nature of 26. Then, my lord, para 6, my lord, under our constitution, only those entities which have been granted legislative power thereunder can exercise such power. Divorce the constitution, such power is only available when granted under the constitutionally valid law. Otherwise, no one has the right to formulate rules which can be enforced. This is significant in the case of religion because the state, as a secular state, is not expected to interfere in the religious matter beyond what power has been constitutionally provided. In recognition of the vacuum under Article 26, embodied in an enabling provision whereby the religious denominations are given the power to formulate the norms and rules regulating their affairs in the matter of religion, but this power of religious denominations is instrumental and not absolute power. Now, my lord, interplay between 26 and 25 it's the foundational principle of the constitutional interpretation that the provision of a constitutional instrument must be read not in isolation, but as constituent part of integrated scheme, each provision drawing meaning from the conferring meaning upon the others. Applying the principle to Article 25 and 26, these provisions are not merely neighbors in the constitutional text, they represent respectively the individual and collective dimensions of a single overreaching value of the freedom of religion, belief, and practice. The structural analysis of Article 25 therefore reveals that it operates at the level of individual. However, under the right to propagate, a person is granted right to transmit their belief to others. A natural consequence of this propagation is the formation of community of faithful, which we may call, my lord, denomination. It is submitted, therefore, that Article 25 serves as a constitutional gateway through which the person professing a common religion faith may, by a natural exercise of their individual rights and to practice and propagate, organize themselves into a religious collective or institution. It is this collective or the institution rooted in Article 25 that Article 26 recognizes.
This has already been argued, Mr. Khanna.
Please, my lord.
This has already been argued well in detail.
Please, my lord. So, my lord, there, my lord, I am going a little deep into it, my lord. Kindly have paragraph 11, my lord. Therefore, my lord, the question which arises is, right to manage religious affairs is conferred under Article 26, whether each and every act done, exercise of this right is consequently so protected under Article 26 as to obviate the entirely the necessity of deference of other fundamental rights of the individual, including those under 20.
That is not the argument also, and that is probably not to that sweeping extent that anybody has argued.
So, my lord, what later I am trying to develop is this, my lord. Under 26, when you are exercising power to make the rules or tenets or whatsoever, my lord, we may call it, my lord, this will be a non-legislative exercise of power of formulating the law. Whether these laws, what will be the scope? That is, my lord, later I am developing. Kindly, my lord, permit me for that. Para 12, my lord, to answer this question is offered through certain proposition. My lord, I have discussed 2 only. In my main note, my lord, I have discussed 7. Kindly para 13, my lord. The power to legislate has been specifically provided under the Constitution to the Parliament and state legislatures, substantially and to the other arms of the government incidentally. Besides other limitations with respect to the legislative powers, an overreaching restriction has been stipulated under Article 13, covering both the laws in force immediately before the commencement of the Constitution, as well as the new laws which may be made by the state, whereby any law, insofar as they are inconsistent with the provisions of Part 3, or which purports to take away or abridge the rights conferred in this part are considered to be void. Then, my lord, in para 15, I have discussed about the definition of law. The only, my lord, place where the Constitution discusses Article 30. And, my lord, kindly a para 16. A bare reading of 13 shows that it takes into fold not only the statutory instruments, including subordinate legislations like bylaws, rules, and regulations, but also includes temporary laws like ordinance and also non-legislative source of law, that is to say custom and usage. And in this case, my lord, it will be through Article 26. As is clear from the inclusive definition of law provided in 13, it does not merely include the acts of legislature, but also, my lord, custom usage and religious custom usage as well. It is submitted that the power under 26B of the denominations to formulate and prescribe their norms for managing their internal religious affairs is also a form of non-legislative law operating within the sphere of denomination. The norms and rules thus formulated and prescribed by the denomination must therefore fall within the scope of inclusive and wide definition of law under Article 13, rendering them amenable to the restriction provided under Article 13 and axiomatically to the jurisdiction of the court in assessing their constitutional validity when challenged in place. Then, my lord, kindly a paragraph 20. In this regard, it must be seen that the Parliament and state legislatures under the Constitution as a collective body composed of the persons who have been elected through a due electoral process by the people of the country. The statutes of the legislature are therefore viewed as representing the will of the people. On the other hand, the religious denominations refer to the collective of persons joined together on the basis of commune, regional identity, religious identity.
Khanna, you can formulate your point and tell us which paragraph, and then we will.
Yes, my lord, I'm just, my lord, this is the next paragraph. What I'm saying is, when, my lord, a state legislature or, my lord, parliament is formulating the laws, they can be subjected to the fundamental rights, my lord. The will of the people, here, my lord, by a collective, a small section, cannot, my lord, be given immunity, my lord, beyond, my lord, what is provided for the parliament and the state. Kindly see, my lord, next paragraph. Any norms formulated by the section of the society can be said to represent only
No,
will
if
of
you
the
read
member.
like this, then it will take a 40 minutes to read, because there are, we have noted the point. You can now next come to the next point.
Please, my lord. So, my lord, kindly have, my lord, paragraph 20.
Your argument is that if the parliament and the state legislature
Please, my lord.
is also controlled through part 3 of the constitution,
Please.
then how can the right of the denomination under 26 be over and above that of the
I'm
parliament?
grateful.
We understand that argument. Now we can proceed next.
Kindly have, my lord. My lord, what I'm saying is the consequence following from 26 in the form of the tenets or the norms or the rules made by the religious denomination, therefore cannot, my lord, have more immunity as over and above the parliamentary laws or the
All right.
state legislative laws. Kindly have, my lord, 22. While it is still to be argued, such immunity is required in the internal domain of the essential religious practice so as to prevent the excess state intervention so as to shield the religious sentiments which are inherently sensitive from being completely wiped away. Any broader formulation of immunity which impinges upon the fundamental rights cannot be accepted, otherwise it would make the will of the people who gave themselves the constitution subordinate to the will of the small section of persons who are conferred recognition of their rule-making power under the very same constitution. My lord, example in para 23, my lord Justice Baki yesterday referred to Article 16.5. That is, my lord, an example. It may be pointed out here that Article 16.5 is almost an example of the above understanding of the religious customs and practices can be considered as law within the meaning of Article 30. Clause 5, my lord, permits, my lord, the appointment only of the persons belonging to that religion or that denomination. I'll omit, my lord, the rest.
Understood that point.
Then, my lord, in next proposition which I am proposing is constitution being the ground norm. The religious denominations rules recognized under the constitution are only sub-norms. My lord, under the pure theory of law by the Kelson, my lord, the ground norm is the basic norm. And your lordship's court has held, my lord, that constitution is the ground norm. Kindly have, my lord.
Then, Mr. Khanna, your argument is contradictory. On the one hand, you say that whatever, because the majority have elected a certain number, the parliament passes and that is final. And then you say the constitution, that is why the constitution has to intervene. It cannot be majoritarianism because of pressure of the electorate. It passes a bill, a government or a parliament passes. This is against your own, you are contradicting yourself. You said, no, the parliament should be supreme. Parliament should govern. The rights of smaller minorities may not be protected. Why not? The constitution is the test. Government may pass, then we have to even, I'll give you a simple example. I could not respond to Mr. Mohan Gopal, Dr. Mohan Gopal. His ground was that we should not interfere because now the majority wants a certain, it is a reform. It is not a reform for the reason you have to satisfy this court. For the reason that suppose today a religion is there, a small number of people come out, establish an institution. Whatever you may, temple, mart, whatever it is, they establish. Now they allow people that look here, we have formed this is our particular ideas. We have this certain rules and regulations. It may be differ from the normal practice, but we are coming out of that. People get attracted, people get faith, they come. Tomorrow they cannot say that, no, maybe you have established on a different principle, but because today in numbers we are more, then we impose ourselves. So we cannot have
That is not my.
Just because today the majority wants a reform doesn't mean that the entity which has itself initiated something, you get attracted, then you say, now I am attracted, now I have the numbers. You cannot have that.
My lord,
That is the protection.
I'm sorry, my lord, I'm sorry I could not convey myself, my lord. That is not my contention. My contention is, my lord, the laws made by the parliament or the state legislature can be tested under 13, can be tested on the, my lord, fundamental rights. So also the exercise of power, when you exercise the power under 26 and make the tenements rules or norms, my lord, for your religious denomination, those rules, powers can also be tested by this court. I'm not saying that the parliament or state legislature can do that.
All right, well taken that one. Well done. Now you can come
Can
to
we
your
have
point C.
on the pure theory, my lord, para 24. As per Kelson's
There is no need to read. We will read this paragraph. Point we have understood. You can now come to point C. Para 29.
I just want to, my lord,
Well,
emphasize.
you are referring to Mr. We will read. There is no difficulties in that.
What I am submitting in Kelson's theory is this, my lord. I'll put it in my words. Kelson, according to Kelson's theory, my lord, the ground norm is the constitution. Under the ground norm, my lord, the 26 is the norm. And the formulation under 26 or the norms laid down under the 26 will be, my lord, the sub-norms.
Yes, you have.
And what your lordship have laid down is the sub-norms will have to give way to the upper layer, that is the fundamental rights. That is what is my submission.
Yes, we understood that. Para 25, 26, 27 deal with it.
Please, my lord. Then, my lord, come to, my lord, C. That is Article 25 is the gateway.
Gateway of
It must be noted that 26 is placed subsequent to 25. It is submitted that the placement is not coincidental, but constitutionally significant. It signifies that Article 25 serves as a constitutional gateway through which the person professing the common religion faith may, by a natural exercise of their individual rights or practice and propagate, organize themselves into a religious collective or institution. It is this collective or institution rooted by 25 that 26 recognizes and protects by conferring upon them set of rights of management of their religious affairs. Then I have referred to, my lord, the schedule.
What you are referred to, yes, we will see it that.
Then, my lord, kindly have, my lord, para 32. It is further submitted that the right of religious denominations under 26B to manage its own affairs in the matter of religion is confined to the governance of the denomination as collective religious institution. The phrase on affairs refer to those matters that are truly institutional in character, such as formulation and preservation of the doctrine, the conduct of ritual or liturgy, the appointment of religious functionaries, and regulation of ecclesiastical officials and internal administration. Article 26B protects the autonomy of the denomination as an institution. It does not confer upon the denomination a plenary authority over the body, integrity, conscious, and personal religious choices of the individual members who constitute it. Then, my lord,
In
kindly have para
comparison,
30.
we are referring to these facts regarding FGM. Those have been argued that not to.
Kindly have para
Let's now
35.
come to locus standi. Locus standi, we are
My lord,
also.
only para 35 and I'll only para 35. This is what I am, my lord, submitting for your lordship, my lord, to exercise your power. The foregoing analysis does not lead to the conclusion that the right under Article 26 is illusory, that every exercise of denominational authority is constitutionally suspect. It instead postulates that this honorable court, as interpreter of constitution and guardian of fundamental rights, must undertake the task of mapping the constitutional boundaries within the zone of protected denominational authority and zone where the individual fundamental rights impose a constraint upon the exercise of collective powers by applying the principle of harmonious construction and the essential religious practices test and irreducibly the constitutional guarantee of individual dignity and religious autonomy embodied in the Constitution. And last, my lord, para 36. My lord, in Carlos' case, despite 31B specifically restricting, your lordships read that fundamental rights will be superior. That is the basic structure. We'll have to test, my lord, every legislation on those fundamental rights.
Yes.
I'm grateful, my lord.
Thank you. Thank you very much, Mr. Khanna.
My lord, I am in an.
In your case, locus is not an issue.
My lord, only one thing, my lord. As your lordships have said, my lord, in certain cases, my lord, if the locus is in a question, when the cause comes before your lordship, my lord, the person will be immaterial. Your lordships have done so right from Sheila Barse, my lord, 1987. Your lordship said the cause is important, not the person. In MC Mehta, my lord, number of cases, your
In any
lordship.
case, we have seen your facts. So you.
My lord, may kindly small submission.
But Rashmir in 5 minutes.
Not more than 5 minutes.
Yes.
Kindly have the written submission and I.
Yes. You can, without a written
Yes,
submission,
my
you can
lord,
start.
you see, divinity runs in the blood of India. In the Constituent Assembly debate 350 times the word God was used. A move was there to include God in the preamble, which was not taken. However, in the third schedule, where the word God has taken place, sovereign, the part was taken first. Dr. Ambedkar said, no, put first God. So therefore, we cannot see any situation, and the Article 26 is the only right which has been created in the for the institution. Rest all the rights, the framework of the preamble is liberty and equality. Liberty becomes freedom, 5 articles based on freedom. Equality becomes a right. When we read Article 26, it is a combination of a guaranteed right and a free on the name of the freedom. We have to see in what context these rights have been interpreted. Certain rights are prohibitions, certain rights are fundamental rights. So as a general note, these two rights are the crucial. One gives the right to an individual, another gives the institutional right. So institutional right becomes supreme. No person can have locus, only subject to public moral order, health, morality. Morality in 26 is different. In concept of the perpetual tradition followed. I'm sorry to say the word custom will not be appropriate to use in the term of the Article 26. Custom, societal custom, tribal custom, very well. When we see the dictionary meaning of tradition, tradition first requirement is perpetual. These traditions are perpetual. So therefore, Article 26 gives the primacy of all other articles. Now kindly read, if I can go with the book, I will explain in 5 minutes. Give me the constitution.
Total for 5 minutes.
Only 5 minutes.
5 is already over.
All right, why, that is, my lord, kindly.
You don't require books, you can state. I know
Kindly,
your.
my lord, when we see 26 shall have the right, 25 is subject to other provisions of the constitution. Therefore, there is a difference. Article 19 gives much more restrictions. Friendly relation, sovereignty, this. So therefore, if we say anything which can affect in any country our relation, I don't have a right. Sovereignty, yes, no, I don't have a right. So it does not give right. Freedoms are regulated or restricted. Rights are not. The word person, three things. People in the preamble means we were not the citizens. Some part of the constitution came into effect on 26th of January 1949. Some came on 26th January 1950. So cautiously the word people was used, we the people of British India. Now Article 29, the certain rights are for person, certain rights are for citizens.
All right.
Now this is right 26 is the institutional right, which is above them. Now what I submit with the advancement of the time, which I have in the last constitution bench also, my lord, just one thing. When there were direct allegations, when I won the case of homosexuality in the first round, I filed a PIL and I said anybody whosoever violates the third schedule, this court as the guardian of the constitution can remove him. That question is question of law is still open. That I have annexed in my written submission. When I filed the Article 154, governors were removed. The pleasure was not defined. Pleasure means irrationality. So therefore, Article 26 shall have the right in relation to institution is a much wider right. It does not require, but with the time. And now looking to the persons have faith, this differently abled senior citizens, the e-pass or virtual, the government of India has come with a 360 temple.in scheme, which is providing the darshan and puja to everybody. So all these females, all other persons can easily be accommodated if the tradition is not disturbed. They can be accommodated. That's what I briefly submit.
Thank you, Dr. Harshvi. Thank you.
Dr. Sharma.
Thank you very much.
Please, my
I
lord,
think
please.
We can now, Mr. Padmanabhan, please.
Any question, my lord? Grateful.
We'll pass it over, we'll ask you.
Well, I made a short written submission.
My lord, if I can, our religious books, which are in the nature of divinity, they tell us the divine morality. 114 chapters of Holy Quran, followed by Hadith, Ijma, Qiyas, 18 chapters of Gita, Srimad Bhagavad Gita, 700 shlokas of Sab-Shloki Durga, all tell us how we have to live. That is our divine character of this nation.
Right.
All tell us this.
Understood.
Grateful.
Thank you. Thank you, Doctor. Yes, Mr. Padmanabhan.
My lord, I have submitted a short written submission. My lord, my contention is that Article 25 is the genesis of a right to religion, and Article 26 is a facet of that right. I'm following Mr. Jai Singh's submissions. I'm
Yes,
not
yes.
relying on case laws and all that.
All of
Just
you are
wanted to,
following. Whatever
just
you want to add,
yes,
you
yes.
are most
I
welcome.
wanted to add something, my lord. This is the interplay between Article 25 and 26. In my humble submission, is the balance between equality of citizens with liberty, which is mentioned in Article 26. 26 is liberty because it gives a space for denominations outside the interference of state in matters of religion. This equality is mentioned in John Rawls. He also mentioned that it is a free and equal citizens of a society that is fair to all. That is the democracy. And according to Ronald Dworkin also, there is no right to liberty independent of a political system that recognizes the equality of citizens. Dr. Ambedkar also suggested, without equality, liberty would produce the supremacy of the few over many. Justice is another name for liberty, equality, and fraternity. Article 25 mentions persons. person, my lord, with due respect, the General Clauses Act will apply only wherever it is, the context otherwise requires, that it will not apply. The person, according to me, should be read along with Article 6 of the Universal Declaration of Human Rights and Article 16 of ICCPR, both of which are adopted and ratified by India. Article 6 of the UDHR, it's at page 12, my lord. Everyone has the right to recognition everywhere as a person before the law. This may be in the light of dignity of the individual. That's the core philosophy of preamble. My lord, in the preamble of UDHR, it's mentioned inherent dignity and of the equal and inalienable rights of all members of human family. That is in the preamble of UDHR and the preamble of ICCPR. Article 51C of the Indian Constitution is a directive principle which mandates that states shall endeavor to foster respect for international law and treaty obligations in the dealings of organized peoples with one another. Therefore, these principles are applicable in my submission, my lord. And therefore, my lord, when you read this preamble, and I wanted your lordships to kindly have a look at that UDHR, some of the provisions, which lordship may kindly see page 25. Page 25 of submissions. My lord, it starts, the preamble states, whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. The inherent dignity is found place in the preamble. And my lord, your lordship is well aware that Article 1 states all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in spirit of brotherhood. Earlier, it was all men. It was by the intervention of a member from India, Hansa Mehta. She has made a change, and then that suggestion was accepted. The men was changed to human beings. As suggested by learned Solicitor General on the first date of hearing, Dr. Jivraj Narayan Mehta was married to her. Yes. My lord, Article 2 also says about rights of freedom without distinction of sex. Article 6, I've already read out. Everywhere, person has, everyone has a right to recognition everywhere as a person before the law. Then, my lord, Article 18 of UDHR is important. It mentions about right to religion. It's at page 28. Everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief, and freedom, either alone or in community with others, and in public or private, to manifest his religion or belief in teaching, practice, worship, and observance. The same principles are followed in ICCPR also, International Covenant on Civil and Political Rights. The religion finds place in this civil and political right document. So my submission is that there is no such dichotomy between civil rights and religious rights. There is interplay between the two, and there cannot be discriminatory practice and say that it is supported by religion. If there is a purification ceremony after a woman enters Shabarimala, then that is a clear infringement of the civil right. That is my submission, my lord. And ICCPR supports that stand because it says, in the preamble itself, equal and inalienable rights of all members of human family, then inherent dignity of human person. It says about enjoying civil and political freedom, universal respect for and observance of human rights and freedoms, having duties to individuals and to the community to which he belongs. Then Article 18 is dealing with freedom of religion. That says freedom to manifest one's religion or beliefs may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, or morals, or the fundamental rights and freedom of others. The language is similar. Something is borrowed from the Constitution, and we have also borrowed something from UDHR because both Hansa Mehta and Vijayalakshmi Pandit were members of Constituent Assembly also. So those ideas are borrowed from each other. So this is supported by the interpretation given by this court also. Then, my lord, rights and duties are correlative. According to Article 51AC, there is a duty to renounce practices derogatory to the dignity of women. And a lot of mention was made about the Irish constitution from which we borrowed this right to religion clauses. My lord, we are not following, luckily we are not following the secularism practiced in Ireland. There was an incident in 2012 when Indian woman Savita Halapanavar, she was pregnant and she was denied a right to abortion, and she has died. And that gave rise to huge mass protest, and the law was changed subsequently. In India, we follow, there may be different views, but we follow only the constitutional morals. We go by either the constitutional values, the statute is very clear. Your lordship is dealing with such cases, and there is no religious value imbibed into all these issues which are of a civil nature. Therefore, my lord, on the basis of these discussions, my submission is that on issues 1 to 3 and 6, the right to freedom of religion is having reasonable restrictions like any other fundamental right. It is not an absolute right. Group rights guaranteed under 26 is in the form of liberty, and it should be balanced against equality to ensure the dignity of individuals. Horizontal application would curtail the liberty granted to denominations under Article 26. There are some articles which was agreed by everyone, Article 17, 23. Even Article 25 will have application horizontally at times. And my lord, the question number 6, all sections of Hindus mentioned in 25(2)(b) excludes none. Because this is an inclusive clause, it cannot be, yes, it cannot be argued to draw a contrary inference. And my lord, regarding questions 4, 5, and 7, since it has got some relevance to facts, I may be permitted to touch upon those things. Every religion, my lord, earlier there was submissions on extreme side on both the sides. There was a submission that Vedas, somebody is not following Vedas and all that. I wanted to just submit that, my lord, every scripture has two parts. First is temporary, and the other one is eternal, which is immortal and universally applicable. For example, Gautam Buddha's teaching of ahimsa or compassion, that is universally applicable. The non-violence of Jainism.
You have already taken more than 12 minutes.
My lord, then my submission is the sum of the core claims of the review petitioners based on religion is not inspired by
individual petitioner.
Yes, then I will read out my submission, my answers to all that.
Can you please give your notes?
Yes.
We will go through. Thank you very much.
My lord, I just wanted to read the answers.
Your time is over.
My lord, then your lordship may kindly.
You asked only for 10 minutes. We have granted you 13 minutes, 15 minutes rather. Yes.
I may be permitted to give 7 minutes, my lord, 7 minutes.
No. You have asked for 5 minutes and we are granting 5.
Please, my lord, 5 minutes, please, my lord.
Just 5 minutes by what?
Please, my lord. My lord, I'm 94-year-old, a Sanskrit scholar, who authored a book on temples in which one chapter is all about temple of Sabarimala. And as such, I was a party to the proceedings before the 5 judges bench also. That's only I can say, my lord. Then that is page number 1 to 4. Then page number 4, para number 2 is about Sabarimala temple. Its relation with the Buddhism, I don't want to say anything more. That is continuation of the practices in the Buddhism. Then, my lord, page number 5 to 8, that is article 25 and 26. My lord, about that, my respectful submission herein is that subject to public order, morality, and health is common to 25 and 26. But there is one word, other provisions of this part in 25(1). Other provisions.
Yes, please.
Other provisions of this part. My lord, Indian Constitution consists of 22 parts, out of which fundamental rights, that is in part 3. Though I can easily import article 21, the most superior right, a right above the fundamental rights, evident from article 359, that is the emergency provisions. Even the life of the state is in danger, article 21 is there. Whatever issues raised is all connected with the dignity. So article 21 will be very much there.
Thank you, Mr. Mehta. Thank
That's
you.
all.
Yes, Mr. Giri.
I'm highly obliged, please, my lords.
Yes, state you
With
start.
great respect, my lord, I appear in 90166, my lord. And here, my lord, I circulate the book written by M.N. Krishnamani, the former president and senior advocate, Shankaracharya, the revolutionary. I have just marked the flag whenever your lordship feel free. You can just read 115 pages only. This is one page which.
You are not relying Shankaracharya because you are arguing that
Lordship,
women have right to enter mosque.
There is a harmony.
Confined to that.
There is one topic here. There is a harmony in Islam and Hinduism. And on the basis of the churning of consciousness in the ocean, the Milky Ocean, Lord Shiva drank the halal. That is how the all-powerful, all-merciful was declared by Muhammad, Prophet Muhammad. So there is total harmony. There is no dispute about that. As far as my matter before your lordship is concerned, it is doctrinal as well as practice. It is admitted by All India Personal Law Board also. I confine my prayer only to prayer A and B, to enter in the mosque and offer the namaz. These are my two prayers, my lord. Not more than that. And secondly, my lord, my submission before your lordship is, there are three types of the mosque. One is, my lord, under Waqf board, directly under Waqf board. Others are regulated by mohallas. And second, by ASI, Archaeological Survey of India. And likewise, my lord, there are temples also, private and state temples. Unless, my lord, my humble submission is, this is the problem occurring nowadays. I am in the current topic, neither on the past or future, but an ancient one. Today, my lord, the problem in the country is that state is trying to take over all private temples under the garb of, because collector is changing the entries, because he is the custodian of the revenue records. And without your, because in the judgment which I am citing, my lord, before lordship, there is the court has held 3 judges in 81 that we can't lay down any estate jacket formula of universal application. The judgment I have annexed with my submission. And my lord, as far as the submission of Mukul Rohatgi and Singhvi sir is concerned, as far as my this morality of these Naga sadhus. Naga sadhus are unlike Jain, because they don't.
Sadhus, you
And this is not immoral, my lord. They come and disappear. They come on the Kumbh period, and they are not naked. With great respect, they don't come. They disappear. They come after 12 years or 6 years. And this is my submission before lordship. My lord, as far as entry in mosque is concerned, page 19 I have written. And my submission would be conscience, as Shri Rakesh Dubey has also said, that conscience, freedom and freely. This should be given a weightage and robust manner should be done. I am following Rakesh Dubey sir's this word, that he said that it should be very much given the, because your lordship said that she includes he and women include men. So all citizens are entitled, or persons are entitled rather, to enter in the mosque and any temple, my lord, because it's the conscience and my faith and belief. That's all. I'm grateful.
Please,
1 minute only.
Mulaz, may kindly grant me just 5 minutes, Mulaz. I'll try to
Start,
yes, Mulaz.
start.
Because I have 2 broad points that I wish to canvass. One is on conscience, the other is on constitutional morality. On conscience, my lords, my submission is that man inherently is a rational being, my lords. Justice O. Chinnappa Reddy, in his dissent in SP Mittal, also pointed it out that it is ultimately the man's capability to reason that travels him and takes him through his life. He creates cultures, ultimately understand what is the meaning of life. Because therefore, I submit that this ultimate meaning of right of freedom of conscience and liberty of thought, because it's not linear. I can be allowed to dissent from a particular faith. I can be allowed to change it, because otherwise, without this ability to dissent from what the popular faith is, because there will not be any social reform. That's the first submission, my lords. My second submission is, my lords, that there is a part of conscience that is absolutely private, that must remain unfettered, inviolable. That is, my lords, also protected by K.S. Puttaswamy, the 9-judge bench, which points out there are certain aspects of conscience that are completely private to me. The reason why I submit this is, my lords, my submission is that the state or any other entity, my lords, does not get to pervade inside my conscience, that is my inner dialogue with my divine, my lords. That's the first submission, my lords. Similarly, my lords, because of the fact that my conscience is absolutely private to me, my lords, my submission is that when I'm entering a temple or any other place of worship, my lords, contrary to what Devaru holds, that entry into a temple is a religious activity, my lords, I'd submit that it is not. Just the entry, my lords, is not a religious activity at all. I can enter for the purpose of art, tourism, history, knowledge, whatsoever. So merely at that stage, my lords, while I'm entering into a place of worship, nobody has the right to question what is my conscience and whether I'm 100% believer in something or I'm a 50% believer in something. That's on conscience, my lords. On constitutional morality, my lords, my foremost submission is, my lords, the learned Solicitor General, my lords, with all due respect, has argued that constitutional morality has no space, my lords, in the Constitution. Lords, I only wish to point out my submissions, volume 2.6 at page 1738. I'm only quoting, my lords, Shaira Bano, the triple talaq judgment. Lords, I only wish to read just 2 lines from that. One of the issues canvassed on behalf of the petitioners, which was spearheaded by the learned Attorney General for India, was on the ground that the constitutional validity of the practice of talaq-e-biddat, triple talaq, was in breach of constitutional morality. The Union of India has also participated in the debate. It has adopted an aggressive posture, seeking the invalidation of the practice by canvassing that it violates the fundamental rights enshrined in Part 3, and by further asserting that it even violates constitutional morality. My submission is, it cannot be that when it comes to triple talaq, the constitutional morality is acceptable. When it comes to other principles, it is not acceptable.
Thank you.
So as an argument for the union, my lords, that may not be
All right,
acceptable.
thank you, Mr. Ved.
My lords, just one final submission I have to make, my lords. Why constitutional morality must always trump public morality, my lords? And I'll only come to, my lords,
That has been argued well. Yes,
lords,
Madam
I'm only
Sneha.
using Sabrimala as an example.
We agree with you on that.
There's no dispute about
Yes,
it.
yes.
Deeply
Yes,
grateful.
Madam Sneha.
Yes, yes, Your Lordship.
2 minutes
Your
or 3 minutes.
Lordship, 5 minutes, 5 points, Your Lordship. I'll be very brief, Your Lordship. My first point, Your Lordship, is on the scope of Your Lordship, Article 25, Your Lordship. The Constitution itself draws a distinction between the inner, Your Lordship. I have circulated my notes also, Your Lordship. The Constitution draws a distinction between the inner freedom of conscience and the external manifestation of religion. Belief is absolute. However, the practice, custom, and the usages when brought into the public sphere remain subject to the constitutional limitation, Your Lordship. And I have relied on 2 cases, Your Lordship, Ratinal and Bijoy, Your Lordship. My second submission is the scope of Article 26, Your Lordship. One of the principal argued, Your Lordship, advanced that Article 26 does not expressly contain the phrase, Your Lordship, subject to other fundamental rights. Now, my humble submission is that, Your Lordship, that non-repetition of the tax subject to other fundamental rights cannot be read at exclusion of the other rights and parts granted under the Part 3, Your Lordship. Therefore, Your Lordship, it cannot be read in isolative a clause, Your Lordship, to give supremacy over fundamental rights. It is respectfully submitted that in the absence of text as being reading and being part of Part 3, Article 26 is necessarily conditioned by the guarantees of other rights of Part 3. Therefore, the granted autonomy is not unbridled, Your Lordship. Now, Your Lordship, my third proposition at page 3 is that the Article 25(2)(b) is a transformative in nature and mandate, Your Lordship. It means, Your Lordship, it applicable to both Article 25(1) and 26, as Article 26 has its source of from Article 25, Your Lordship.
Understood.
There, Your Lordship, I would just wanted to say one thing, Your Lordship. The test of doctrine of compatibility is needed, Your Lordship, to balance the religious practice and constitutional ethos while bringing social reform to a particular practice of custom or uses whenever there's a conflict with the fundamental rights, Your Lordship. Now, Your Lordship, also, Your Lordship, 25(2)(b), Your Lordship, my humble submission is that the state to enact laws for social welfare and reform, including throwing upon public religious institution to all classes and section of Hindus, including Hindu women, thereby prohibiting any form of exclusionary practice based on notion of purity or stigma-based practice, Your Lordship. Now, Your Lordship, therefore, Your Lordship, my humble submission is that the expression all classes and section deserve a broad and purposive interpretation consistent with the constitutional ethos and substantive equality, Your Lordship, including women. Your Lordship, now, and also, Your Lordship, this 25(2)(b), Your Lordship, operates not merely a limitation upon Article 25(1), but equally as a constitutional check upon denominational autonomy, Your Lordship. Now, Your Lordship, I wanted to apprise Your Lordship about one book, Your Lordship, Founding Mothers of Indian Republic, authored by Achyut Chetans, Your Lordship. He, while narrating the role of founding mothers, Your Lordship, of the Constitution, stated that though few in number, that women played a significant role, either through direct intervention, rejoinder, comments on the floor of the assembly, or by evolving strategies amongst themselves to ensure that certain issues were brought in the debates, Your Lordship. And here, Lordship, the relevant experts of the constitutional debate, Your Lordship, I will not repeat, Your Lordship. G. Durgabhai is one of the constitutional debate which says about the Article 25(1). And Your Lordship, if I may quote one line of that, Your Lordship, if I may be permitted.
One line, one line.
One line, Your Lordship, yes. So my object is to enlarge the scope of the clause and include within all classes and section of the Hindus. If amendment is accepted, then the object will be fulfilled. As I have already explained, there should not be any distinction between the class and other class of the Hindus, Your Lordship. And one more relevant debate, Your Lordship. It's not debate, Your Lordship. Aims and objectives while passing by Pandit Jawaharlal Nehru by resolution, Your Lordship, volume 1, 13 December 1946. He stated specifically in the aims and objective the relevant resolution I have quoted, Your Lordship. I beg to move the Constituent Assembly declares the firm and resolved wherein shall be granted and secured, Your Lordship, to all the people of India justice, social, economic, and political equality of status, of opportunity before the law, freedom of thought, expression, belief, faith, worship, vocational, association, action, subject to public law and morality, Your Lordship. Yeah. And also, Your Lordship, in that, Your Lordship, Hansa Mehta has given a very important observation, Your Lordship. If I make, quote 2 lines of hers, Your Lordship. The average woman in the country has suffered now for centuries from inequalities heaped upon by her laws, custom, practices of people, and who have fallen from the heights of the civilization of which we are so proud, Your Lordship. So this is a quotation, Your Lordship. Now, Your Lordship, interplay, harmonious constitution construction needs to be read. Now, Your Lordship, my last, Your Lordship, and the foremost important, Your Lordship, on the 5th point, Your Lordship, is that the exclusion of women based on notion of purity is violation of Article 14, 15, 21, and it's also a concept of constitutional ethos underlying the Article 17, Your Lordship.
Understood.
And Your Lordship, and then Your Lordship, this, Your Lordship, focus, Your Lordship, on constitutional vision cannot permit biological processes unique to women to become grounds for exclusion from public religious institution, Your Lordship. And therefore, my humble submission is that the custom originating centuries ago cannot remain immune from constitutional scrutiny in the modern constitutional democracy governed by transformative constitutionalism and constitutional ethos, Your Lordship. Here, Your Lordship, I'll just give one reference of, Your Lordship. In Nepal, Your Lordship, there's a Chopadi system, Your Lordship, where a menstruating lady had been thrown out of the village and they kept for 5 days, 7 days in a mud hut. I'm just giving a comparative analysis, Your Lordship, that there, Your Lordship, they don't allow to enter home, temples, and other public spaces, Your Lordship. So that is just a notion on the menstruation and the notion on the purity. I'm just giving this example, Your Lordship.
Thank you.
And last, Your Lordship, there are certain convention, Your Lordship, international convention.
Last was the last.
Last to last, Your Lordship. Half a minute, Your Lordship. There are certain international convention. I have mentioned your.
Read out to him.
Yes, sir. Yeah, I'm deeply obliged, Your Lordship. Your Lordship, there are 3 conventions which I'm citing, Your Lordship. Under the Convention of Elimination of All Forms of Discrimination Against Women, that is CEDAW, the states are obliged to eliminate customs and practices based on gender stereotype. And Your Lordship, UDHR is very important, Your Lordship, as my learned brother has already been stated, Your Lordship, the cultural religion.
Also and everything.
Yes, and 18, Your Lordship, the Convention of ICCPR. And the last, Your Lordship, 2 seconds, Your Lordship. Even the philosophical foundation of Indian spirituality, they itself recognize equality and universality of human dignity, Your Lordship, which can be also be seen in Bhagavad Gita in chapter 5 and verse 18, which says, the wise see with equal vision, a learned and a humble Brahmin, a cow, an elephant, a dog, and even one who considered an outcast. So, Your Lordship, the aforesaid verse reflects and civilizes constitutional ethos of equality, inclusiveness, and equal spiritual worth
All right,
of
thank you.
every individual.
Thank you very much. Thank you.
Much obliged, Your
Yes,
Lordship.
Mr. Kaustubh Chaturvedi, 2
Deeply
minutes.
obliged, Your Lordship.
Just 2 minutes now.
I'm only going to make one argument, my lords. If I can make myself clear in 2 minutes, nobody will be happier than me. A number of counsel from both sides of the bar have tried to persuade your lordships of the proposition that when dealing with a situation where there has arisen a conflict, where we are not able to harmoniously read, where there exists necessarily now a conflict between two fundamental rights, likely in the situation 25 and 26, that proportionality is a sufficient solution. I aim to unsettle that assumption and tell you that proportionality is not sufficient, that double proportionality must be adopted, and that if your lordships in this 9-judge bench, which by my estimate is maybe the 17th time you're sitting in 9 judges in 80 years of this republic, lay down that the rule is proportionality and proportionality alone, it will have significant deleterious consequences for every future case which will deal with the situation of competing fundamental rights. Now, why is this? The doctrine of proportionality arises from the context of a contest between the individual and the state. Proportionality asks the question, is this measure, is this practice a proportionate infringement on my right as a citizen? It was never evolved and it was never meant to ask the question, is the striking down of this practice a proportionate infringement of that other individual's right, of that other individual's other right for that matter? That question can be answered only using double proportionality, and I cannot emphasize this enough. This is not academic. Let me show this for a moment by illustration. Perhaps the classical example of adoption of proportionality in the context of two rights, more recently at least, is in the context of Puttaswamy 2, in the context of the Aadhaar Act, which was challenged at the time. In that situation, your lordships had adopted single proportionality, proportionality simpliciter. Your lordships went through all 4 prongs, one by one, and in the 4th prongs, your lordships finally held that there is no disproportionate impact on the right to privacy. Your lordships noted that the right to food of individuals was at stake, that was getting supported in some way by the Aadhaar Act. But at any rate, your decision turned on one fact and one fact alone, that there was no disproportionate impact on my right to privacy. Now, take for a moment a situation where there was such a disproportionate impact. If the provisions of the Act had been marginally worse, or your lordships had thought slightly differently, what would the necessary consequence of that have been under simpliciter proportionality? There is no right, no power, no place in that framework for this court to then consider would striking down the Aadhaar Act have a disproportionate impact on the other individual's right to food. That factor must be considered. If your lordship is striking down a measure which has a significant impact on another right holder, your lordships must consider what impact it will have on that right holder. It is for this reason your lordship in electoral bonds and double proportionality is the standard. I could give more examples in 25 and 26. I will not burden your lordships with that at this moment. You may have my note for that. One last thing though I will say, electoral bonds was Article 19. We are dealing now with 25, 26. These are essentially sui generis rights because of how they operate in the Constitution. If your lordships could for just one moment, my note has been circulated, just have page 10. On page 10, I have laid out a chart, a framework essentially, for how double proportionality should be applied in the specific context of contests of Articles 25 and 26 alone. I will only show your lordship 3 things in that chart because those 3 things are deviations, perhaps to some extent, from the way your lordships would conventionally do double proportionality. Do my lordships have page 10?
You can give us,
I hope
yes, we will see from your note. You can explain that.
Yeah, my lordship. So 3 things only on deviations. First of all, your lordships, if you have page 10, will see from the top, the second block in the middle is one of the 2 competing fundamental rights, a trump essentially. Is it Article 17, 23, 24, bodily autonomy under 21? So I would submit that if one of the rights is 25 or 26 and the other is one of these, there is no question of double proportionality being entered into. The balancing does not happen. The trump trumps. The second unusual aspect that your lordship must consider in this double proportionality analysis is between the questions of is on the question of whether the measure has a legitimate purpose or the practice has a legitimate purpose. I would submit that in any case where we are dealing with a conflict of a 25 or a 26 right with other rights, all practices will have a legitimate purpose. Essentially, this prong will always be satisfied because the practice is always going to be for the furtherance of some or the other fundamental right. So on the prong of suitability alone, it cannot be struck down. And so that your lordships must note. And the last thing I want to draw your lordship's attention to on this is at the very bottom right before the last block. There's this little question. Is only one of the 2 rights in question a 25 or 26 right? Now, why do I say this? Many counsel here have taken the argument, I adopt that argument, that 25 and 26 are a complete code. If they are to be read as a complete code, if they are to be read together, then if Article 25 is subject to Part 3, Article 26 is also subject to Part 3. Now, what does this mean? If it's 1724, that's a trump, that's different. But for all of the other rights, I'm still circumscribed. So you balance, you do the measure. But at the end of the day, if the other measure also goes through all three prongs of the proportionality test and it survives, it is the least restrictive measure, for example. If all of that happens, then that right must triumph. In that context, at least it must. So, Your Lordship, that's all I had to say. In closing, I will only flag that Your Lordship should be cognizant of the fact that electoral bonds does not simply say double proportionality should be considered. It says it is the standard for a situation of competing rights. So, to detract from it is a substantial decision which would have weighty consequences, and Your Lordship should not disregard it or do so lightly. Thank you for your indulgence.
Thank you. Shashwati,
My lord's taking my baton from the
2 minutes or 3 minutes?
in this marathon. I will place only two.
Yes, don't open your laptop, start.
I shall close.
Yes, we would like to, yes.
My
we
lords,
would have
there are only-
different tips.
There are only 2 points, my lords. One is the fact that this is not merely a conflict between a group and an individual. I would just like to say that as a denomination is a group, so are the people who are excluded are a group. Those who are individuals, they form the group. You exclude one woman between 10 to 50, you exclude all women between 10 to 50, and so are they a group. So the question that arises here is, when there is one group who's seeking a right under 26 and another group who can seek a right between under 15 as well as under 21, what is the right way to go about it? The fact that there was horizontal application attached to Article 15 goes to show that Article 15 can be enforced against other groups as well. And for that, my lords, I'm relying on just one judgment. In second page, my lords may not open it. It's the Noor Jahan Shafi Nayaz versus State of Maharashtra. This was about upholding the right of women to enter the inner sanctum of Haji Ali Dargah. Here, and only the impacted portion I'm reading, once a public character is attached to a place of worship, all the rigors of Articles 14, 15, and 25 would come into play, and the respondent trust cannot justify its decision solely based on a misreading of Article 26. Respondent number 2 trust has no right to discriminate entry of women into a public place of worship under the guise of managing the affairs of religion under Article 26, and as such, the state will have to ensure protection of rights of all its citizens guaranteed under Part 3 of the Constitution, including Article 14 and 15. This is to say that Part 3 has to be considered when Article 26 is being read.
Article 25 and 26 are also part of Part 3.
Precisely.
Nobody has argued what is the meaning of subject to the other parts of the Part 3 till today.
My lords,
There is no assistance on that. Your side is saying that all articles from 14 to 24 will prevail over 25 and 26. Forgetting the fact that 25 and 26 are also Part 3. That is the whole object of this 9-judge bench.
Obliged, my lords. If I could assist on one, only just to address.
We are just mentioning this.
The
17th day. Please sit down.
I understand my leadership's question. The only answer I'd have to give to that is subject to Part 3 would mean that all rights of Part 3. And what would then it mean if 26 talks about managing
14 to 24 and forget about 25 and 26.
No,
that is
absolutely no, my lords. Absolutely not, my lords. It's the fact that Article 26 talks about managing of affairs, and 15 talks about not discriminating against sex. The both do not have to necessarily be in conflict. One may manage affairs while not ostracizing a sex, religion, and a caste. That is how subject to Part 3 would, in my humble submission, be read. The only second point I would like to raise, and this is because a phone call had come to me as nodal counsel that someone wanted to address issues because they told me that how do we approach the court when everyone will know our name? And for this, I raised the second issue on public litigation. The only aspect I place here is, it is imperative to note that individuals who are subjected to exclusion or socially conditioned to internalize such exclusion are those who are directly affected, belong to a close-knit community. If they come to court or their name comes to court, they are the ones who face the highest amount of ostracism and excommunication. And only in those scenarios, a third person may in fact aid them in advancing their issue. And to that extent, public interest litigation should, in fact, my lords, be allowed, because injustice anywhere is a threat to justice.
Thank you. Yes, Mr. Anand. 2 minutes.
My lords, I'll just take 1 minute, 2 minutes by the clock. My lord, if I may just circulate one pager for the court's benefit.
and other copies are here. My lords, I am the last counsel of this side, so I have had the benefit of hearing everyone on that side and everyone on this side. And my lords, my conclusion is that everyone's thrust, insofar as a conflict between other parts of Part 3 and 25 and 26 is concerned, has been on harmonization, balancing, proportionality, basically finding a way to give effect to both rights. My lords, I have only one proposition to advance, which is that hard claims arising under Articles 25 and 26, in those cases, the principled argument of constitutional morality can be the only resolving principle. Now, my lords, two essential questions arise. What are hard claims? My lords, in para 3, I say that hard claims are those absolute extreme claims of religious practice, where the logical end of the practice is only death. My lords, I give three examples. The first is the example of Santhara, which is practiced by the Shvetambara sect under Jainism, which is akin to fast unto death. The second example is this practice of prayopraveshanam, which is the practice of voluntary fasting unto death, which is practiced by certain yogis under Hinduism. And the third practice, my lords, is the practice of soku shinbutsu, which is a practice of self-mummification practiced by certain Buddhist monks. Right now, it is criminalized in the country of Japan. My lords, my submission is that these are hard claims. And why do I say that? For two specific reasons. The first reason is that these are cases where Article 21, right to life, or the right to health, as occurring in 25 and 26, these rights are in conflict with the rights of the same individual who is also claiming their right to practice under 25(1) or 26p. So in effect, your lordship, this is not a conflict. This is them saying that I want to waive my right to life under 21, or I want to waive my health under 20, as occurring in 25 and 26, so as to practice these practices of Santhara or say Prayopraveshanam or Sokushin Butsu. My lords, the second argument is that in such cases, the principle of proportionality or harmonization will not apply, it will not work, because giving effect to one right will automatically mean that the other right is nullified. If right to life is upheld, 25 goes, or if the practice is upheld, then your life ultimately goes. So my lords, what is the solution that I propose? The solution is that in such cases, the principled argument of constitutional morality will come to privilege right to life over the religious practice, because in a post-constitutional rights-based order, certain inalienable rights attach to you, whether or not you wish to enjoy such rights. In other words, my lords, such rights cannot even be relinquished by will. My lords, just two judgments I cite. In Olga Telly, my lords have said that fundamental rights cannot be waived off. Once again, my lords, this is not a case of conflict. This is a case where a person wishes to waive off their fundamental right. And this is where the state enters in its parents' patria jurisdiction and says that even if you want to waive off that fundamental right to life, you cannot do it. Then, my lords, in another case of Narsingh Pal versus Union of India, your lordships have said that fundamental rights cannot be bartered away. So, my lords, my submission is that right to life under Article 21 being such primary inalienable right, it cannot be waived off or bartered for the enforcement of another fundamental right, even with express consent, undertaking, or concession. My lords, therefore, the sequitur of my submission is that non-alienability or waiver of primary inalienable right to life forms a core normative content of the principle of constitutional morality and comes to resolve a conflict of fundamental rights where hard claims arise under Article 25(1) and 26p. Grateful.
Thank you. Thank you very much. Thank you.
I wish to have only 1 minute of your time, because I believe that some of the submissions made on this side, I, of course, disagree with some, but they may be jurisprudentially flawed, and therefore I will not take more than 2 minutes of your time. I will put it on record. Well, Lord, let's first take the question of proportionality. I think my learned friend addressed it very well. However, my Lord, I wish to point out that the doctrine of proportionality has never, ever been invoked when there is a clash of two fundamental rights. For the last 75 years, it is invoked mainly as a doctrine of administrative law, following the Wensbury principle, where the issue is whether state action is arbitrary or unreasonable. Therefore, my Lord, if your lordship wishes to invoke it, it's a different matter. But this court, in that stead, has given you the only test in Devaru, which is harmonization of rights. And there, my Lord,
the court has taken the two triple tests, my lord. Essential practice, secondly, harmonization of two fundamental rights, one with the other. Issue never arose before that and has not often arisen in this court. And my lord, that is the second thing. And therefore, my lord, unless you want to replace, and the third thing in Devaru, which people have not given adequate attention to, is that check whether it causes substantial injury. If it causes minor injury, you can see which right to give precedence to. But when there is substantial injury, then you will have to decide which gets eclipsed or which is slightly lower than the other. So, my lord, I suggest we stick to the principle of harmonization of fundamental rights. There is only one other judgment of this court on the question of harmonization. It arose in the context of HIV/AIDS. There was a person who had HIV/AIDS who wanted to get married. And, my lord, he did not disclose this to his fiancée. The matter reached the Supreme Court of India. In that case, both claimed fundamental rights. He claimed a fundamental right to marry and confidentiality, and she claimed a fundamental right of bodily integrity. Again, this court, the judgment is X versus Y. I don't have the citation, I'll give it to you. Use the doctrine of harmonization of rights. So the harmonization principle read with the essential religious practice test, which goes along with harmonization, and substantial injury, 75 years. It has stood the test of time. My lord, one question on untouchability. Question was asked, why is it in inverted commas? I have read literature which I will provide. The word untouchability did not exist in the English language till the 19th century. That is the reason why it has been put in inverted commas. Now you will probably find it. I wanted to ask my learned friend, Mr. Subramaniam, who has the 19 volumes of Oxford. I don't have it, but I do intend to visit his library and check whether the word untouchability is to be found in those 19 volumes. It was not there till the 19th century because the phenomena existed in India. Then, my lord, the last thing, just one on Nepal. Nepal made a commitment to the CEDAW committee that we will go back and abolish this practice of putting women out, putting menstruating women out. They went back to their own country and they changed their laws. And they said women can no longer be discriminated against for untouchability. Well, I'll put all this in writing and give it.
Thank you very much. Yes, Mr.
Well, one last thing, please. An unanswered question. Why does 25 have subject to the... There is an answer which no one can give you. The reason is there is no debate on this in the Constituent Assembly debates. So we don't know why this provision was put there. But a possible solution, a possible interpretation is only those rights which are naturally applicable will be within the definition of other provisions of Part 3, because it otherwise seems redundant.
Yes.
Everything is subject to Part 3. So why is it there? We don't know, but to be honest, because there is no debate. So yes, your lordships will have to interpret it for the first time. And I suggest you may want to invoke the doctrine of as applicable, as may be relevant, as may be applicable. And there it will be the lateral rights.
Yes, my sister has put that same question also going through my mind. What do you think will be the constitutional Part 3 rights that will be available to an individual who questions the religious practice of a denomination? What do you think? What were the articles that might possibly you can factor into under Part 3?
It will be.
In general, we are asking because we have to interpret this way. My sister is also asking because
certainly all
we also have the same doubt. Yes.
Certainly all the lateral rights.
If that is so, if it is available, what could be the remedy? Can you still say that no, this being a denominational right on the one side, or even say collective right under 25(1) on the one side, vis-a-vis the rights of the member who seeks to question it, maybe on the question of civil right violation or under the Constitution. What is the remedy that person can see? Can you maintain the petition?
The question of remedies really shouldn't trouble anybody, because if it's a question of untouchability, you will have an Article 32 remedy for sure. But remedies, my lord, is not the issue over here. I have said we are willing to go under section 9. There are amazing judgments of this court which say any suit can be filed under section 9. Why? Because there is nothing like a right without a remedy. You be just judi remedium.
We also don't
For
say
that, section 9 is provided in the Civil Procedure Code.
We need to, both of you to give us some insight into this. As my sister asked a question, pertinent question, we need to say, what do you mean by the subject to part 3? That's, I think, hopefully we can also ask the.
Your Lordship should really look into this issue. What I'm saying is, to the extent relevant, maybe one answer. Maybe that is why this question is troubling, because 26 is also part of part 3. So when you say subject to part 3, are you saying subject to 26? That's the obvious question, isn't it?
It depends upon our understanding.
We will try our best to answer.
My lord, your lordship will really have to ponder over this issue.
Thank you.
Yes,
Wait, please,
Mr.
Lord. Lords, I have circulated the rejoinder submissions, and I'm not going to read them. So that's the first and best part of it.
Our request only will be, because maybe that after you, that there are some brief submissions from.
Yes.
Senior counsel also. Just only to the point which need to be clarified, otherwise you can give us a written.
No, certainly, my lord. I will be concerning myself with the propositions only. My lord, some of the questions which fell from the court and some of the issues which the other side raised and which needs a little answer. My lord, my first and foremost submission is, my lord, that in all these judgments in past, my lord, the question which we posed or question which the court posed was a reverse question. Whether this is a real religious practice or not, and if yes, whether it is an essential practice or not. My lord, my submission, my lord, in para 6 is that the real question, my lord, for the purpose of adjudication, whether here or anywhere else before any other forum, would be whether the practice in question is against public order, health, morality, violates any of the fundamental rights, and if all the questions are in the negative, then Article 25 will apply. We are putting
presumption of it being a religious practice.
Yes.
Then there will be a constitutional presumption that it's a religious practice duly protected under 25(1), unless the onus is discharged by the other party, that it falls in the 3 exceptions.
Yes. So the my lord, all judgments your lordships would say whether it's a religious practice, and B, if it is, then whether it is essential or integral part of it. Lord, there the difficulty is this. Lord, your lordships are examining and explaining the fundamental rights. Lord, judgment after judgment, right from 1950 at least, the view is that the fundamental rights would be given most expansive meaning. Article 25, 26 are the only articles where courts have given restricted meaning, that we will protect only if it is essential. From where do we get that? Essentiality test is, my lord, not only textually absent, it is also, my lord, not permissible because we are interpreting the constitutional scheme. Lord, now kindly see, my lord, the moot question, my lord, which we are not getting an answer to. What is the interplay between 25 and 26? The other side argued, my lord, that 26 is a standalone provision. Some of my learned seniors also argued that it is a standalone provision. Lord, my stand was and is that they are to be read together. Lord, for that purpose, Lord, I reread part 3. Lord, please come to page 3. My lord, bottom is the pagination. The part 3, my lord, incidentally has subheadings, my lord. Part 3 is, my lord, fundamental rights is the main heading. It has subheadings. My lord, I am going to, my lord, show that each article is grouped together under a particular subheading. My lord, please see, general is 12 and 13, right to equality, article 14 to 18, right to freedom, 19, 21, 21, 19, 20, 21 and 22, right against exploitation, 23 and 24, right to freedom of religion, article 25 to 26. Lord, we will have to read this as a subchapter internally dependent upon each other. And I'll also point out, my lord, if it is not so read, and if 26 is read as a silo, a separate island, what would be the consequence on other articles, my lord? I'll not show that. Cultural and educational rights, 29 and 30, and the right to constitutional remedies, 32 and 34. My lord, kindly see, my lord, now. My lord, kindly take the constitution, my lord, for a second, my lord. Why? What would happen if your lordships were to read 26 as a standalone provision, an isolated provision, an island provision, or a silo? What would happen? Well, the argument on either side is based upon the fact that textually 26 is not made subject to part 3. Correct, my lords? I need not read, my lord, 26 subject to public order, morality, and health. Every religious denomination, so and so, so and so. Now, if we were to accept, your lordships were to, your lordships were to accept that in absence of specific mention of part 3, other provisions would not apply. Lord, please see 29, Article 29. What would happen to 29? Protection of interest of minorities. Here, this is not made subject to part 3. Any section of citizens residing in the territory of India or any part thereof having a distinct language, script, or culture of its own shall have the right to conserve the same. No part 3 rights. And no part 3 caveat. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on the ground only of religion, race, caste, language, or any of them. Please note, my lord, gender or sex is not involved. It is not accepted.
So they are minority rights.
No, but gender and sex is also included because we are reading 29. We have been reading 29 with 15 and 16. 15 and 16 are rights against discrimination based on sex. So if, my lord, textual absence of the term part 3 of the Constitution leads to a conclusion, according to the arguments, that it would not apply, my lord, then all the articles where there is no textual reference, my lord, would be isolated silos. My lord, I don't think that can be, my lord, a correct interpretation of fundamental rights, because the word fundamental is not just, my lord, a superfluous word. Fundamental rights means it inheres in me already. It was there. It is just being manifested when Constitution is made.
No, Mr.
So,
Mehta.
14.
No, Mr. Mehta.
My lord, its minority means a linguistic minority, etc. My lord, cultural minority.
That
Not,
Article 19 has to be read because it is not, sex has, or gender has not been mentioned. It is not required. It is not necessary that it is being read in relation to Article 19. In fact, it is being read simpliciter because any section of citizens, so citizens itself covers everybody. So 29.
I'm sorry, my lord, I could not explain myself.
So that is why there was no need that probably you are trying to project that unless the other parts, sections or articles were also read, this could not be given. Not required. Without that, the citizens covered everybody. Citizen doesn't have any male or female. So nothing support is required from any other article.
But when it says it cannot be discriminated on the ground of religion, race, caste, language, or any of them, then the word is absence. That's my submission. I leave it at that.
Everybody.
Lord, I think, Lord, I have made myself.
May have a race, may have a, what is that?
This is concerning linguistic minority.
Your argument is simple, that the absence of an expression like sex or gender does not mean that this article permits discrimination on that ground. That is what probably.
That's another, and I'm not repeating it in detail, but the proposition is that after R.C. Cooper and Coelho judgment, it may not be permissible for the court to say that any article under Part 3 can operate as a separate independent article unconnected with other articles. So 26, 25 and 26, I wanted to just show the connection between the two, why they are clubbed or grouped together. Lord, 25 are individual rights. Right to practice, propagate, and if we take, my lord, the preamble, the faith, belief, and worship. That is the right granted. I can, my lord, enjoy those rights as an individual. I need not be a part of any denomination. I'll come to denomination. My lord, what is the significance of denomination? Because one of the questions that fell, which was possibly not answered. I need not be a part of any denomination. My lord. I can remain a Hindu, I can remain a Muslim, I can remain a Christian without being a Protestant or a Sufi or a Shaivite or anything. My lord. But if more than one person's subscribing to a particular ideology, a particular religious doctrine, a particular origin of doctrine, or a particular method of worship come and get together, 26 is a manifestation of the very same right in collective form. Therefore, for individuals, right is to propagate, right is to practice, right is to profess. Yes, sir? You can dispute after I complete my submissions, yes. No, then quietly understand. So, my lord, my respectful submission is that 25, 26, 25 gives right to profess, practice, etc., which is not available to, my lord, the denominations. Lord, your lordships, my lord, a very right query came from your lordships that denomination, should it have a particular name or a particular registration, or is it a person or not? Person, juristic person or not? Lord, that is, my lord, a very pertinent question, and I would like to a little elaborate on that. Lord, under the Indian scheme of things, my lord, whether we take Hinduism, Christianity, Islam, Buddhism, there is, my lord, a religious unity, but at the same time, there is internal plurality. And there is a possibility, and I'll demonstrate, of there being a denomination without any registration or any juristic personality, and a denomination within denomination. Take, for example, my lord, Hinduism. Hinduism is a way of life, it's not a religion, my lord. Forgetting that for the time being, treating Hinduism to be a religion. Vaishnavites is a denomination, my lord. Nobody can dispute that. When we say Vaishnavites, it is not confined to Krishna worship, Lord Krishna worship, because Lord Ram is also considered to be one of the avatars of Lord Vishnu. So those who are, Lord, those who follow Ram, or they preach Ram, Lord, teachings, they are also Vaishnavites. Now that is one denomination. Vaishnavite is a denomination. Shaivites is a denomination. Shaktya is a denomination. Now take, for example, Vaishnavites. It's not just Vaishnavite. I can be a Vaishnavite, but, my lord, I will have, my lord, there are 8 sampradayas, 8 denominations, separate, not sub-denominations. It was my mistake in use of the expression, which owe their original theory and the jurisprudence and the religious doctrine to Vaishnavism. My lord, one is Sri Sampradaya, my lord, started by Ramanujan. Lord, that is Vishishta Advaita. That's the theory, that's the religious philosophy which was started. So Hinduism is a religion, Vaishnavite is a denomination, and within Vaishnavites, Ramanujam Sampradaya is a separate independent denomination. Now, if it wants to acquire property, if it wants to do anything within the meaning of Article 26, Lord, they may require registration. There are mutts. Lord, for example, Brahma Sampradaya is Madhavacharya. Dvaita, Lord, that's the theory, my lord. They have mutts, and there is, my lord, a system going on, my lord. Every 2 years, my lords are aware, my lord, the Mathadhipati changes and etc. My lord, there are internal. Then Rudra Sampradaya, my lord, that is called Shuddha Advaita. That is a separate denomination, but a part of Vaishnavite denomination. So there can be a denomination, full-fledged denomination within.
They come under sects.
Yes, my lord. Sanat Kumar, Nimbakacharya, my lord, very popular, Nimbakacharya. And Gaudiya Vaishnava, my lord, my lord Justice Bakchi would be knowing more. Chaitanya Mahaprabhu. That is again a Vaishnavite movement. It is a denomination. It may not be registered. It's not necessary.
Then Vaishnavite, as you said, under Ramanujacharya, there is also what is called Tengalai and Vadagalai.
Exactly. I was, my lord, not going into that. I have that chart, my lord.
No, again, separate those who are,
Yes, yes, my lord.
and the difference is in the U or the V namam.
Yes, now, my lord, yes, my lord, their tilak is different, their salutation is different. Their way of wearing clothes are different. Their rituals are different. Same is Shaivites. My lord, Shaivites is more elaborate. My lord, I have I don't wish to, my lord, make this a lecture on, my lord, other denominations, but there can be, my lord, there can be a small denomination. My lord, whenever, my lord, Madhavacharya ji or Madhavacharya ji or my lord, anyone.
The understanding of 26 as such.
Yes. So, my lord, the question was whether.
There the other side has raised only with regard to 25-1.
Yes.
Their thrust is on 25-1.
No, my lord, the difficulty is this, my lord. The Constitution very consciously and advisedly uses the word because the framers of the Constitution were aware about this internal plurality. It's very clear that they were aware about the internal plurality, that they are not dealing with one particular religion practiced throughout the country without any internal plural divisions. And therefore, in 26, please see, my lord, and this is not noticed by any judgment so far, including Sabrimala. And Sabrimala relies upon SP Mittal. SP Mittal also does not notice this constitutional expression. Please have a look, my lord. 26. Kindly, my lord, for my satisfaction, have a look at 26. Subject to public order, morality and health, every religious denomination or any section thereof. They were aware about the internal plurality, that there can be a section of denomination. Lord SP Mittal, which lays down the test of what a denomination would be, in para 80 of the judgment. My lord, please see, my lord, just for immediate reference, my lord, at page 7 of my submission, my lord. This is, of course, a majority view. Minority view has, my lord, taken a different view, of course, without noticing section thereof. Please have a look at, my lord, page 7. Because, my lord, my respectful submission is that SP Mittal is a wrong law and requires to be, my lord, overruled. Please have a look, my lord. Para 34. I am not, my lord, reading anything else other than what is relevant. The words religious denomination, this is SP Mittal, 5 judgment, my lord. In Article 26 of the Constitution must take their color from the word religion, and if this be so, the expression religious denomination must also satisfy 3 conditions. 1. Now, my lord, this is what your lordships declared to be a law, which came to be followed in Sabrimala. And Sabrimala, based on this, says that Ayyappans is not a denomination. Therefore, my lord, I am emphasizing this is not a good law because it does not take into account section thereof. Please have a look. It must be a collection of individuals who have a system of beliefs or doctrines which they regard as conducive of their spiritual well-being. That is common faith. Correct, my lord. Common organization. Not necessary, my lord. There need not be any organization. I am a Shaivite. I need not belong to any Shaivite organization, whether registered or not. And third, designation by a distinctive name. This is, my lord, wrong, and I can make a statement without, my lord, any fear of being contradicted. In the entire judgment, majority view, the religious denomination or any section thereof is not noticed. My lord, Ayyappans may be a section of some denomination. Why, my lord, why, on what ground can they be denied fundamental right? Because there is a judicial definition evolved. Ultimately, judicial definitions are artificial definitions, my lord. My lord, I have also quoted the minority view of Justice Chinnappa Reddy on the next page. I would earnestly urge your lordships, my lord, to read at page 8, para 36, in SP Mittal itself, my lord, but it's a minority view. I must, my lord, at the outset say, it will be noticed that these sects possessed no distinctive name except of their founder teacher. Now, this was Aurobindo. and had no special organization except a vague, loose, unknit one. The really distinctive feature about each one of these sects was a shared belief in the tenets taught by the teacher founder. Judicial definitions are not statutory definitions, they are mere explanations, every word of which is not to be weighed in golden scales. Religious denomination has not to owe allegiance to any parent religion. The entire following of a religion may be no more than the religious denominations. My lord, there, Justice Chinnappa Reddy also, my lord, did not notice, my lord, the section thereof. My lord, thereafter, in Sabarimala, the majority cites SP Mittal. Ayappan's lost as being declared denomination on the ground of SP Mittal. But there is a minority view in Sabarimala of Justice Indu Malhotra. I am not reading, please note the para 485 and 499, where her ladyship takes the view. Of course, she also does not notice, my lord, unfortunately was not brought to her notice, section thereof. But she does say denomination or any sect thereof. It's loosely worded, but my lord, none of the judgments notice section thereof. And therefore, my lord, both the judgments are wrong. There can be a denomination, denomination within denomination, and denominations within even those denominations. That's the plurality in every religion in this country, and this is a country specific.
That section thereof is constitutionally recognized. Power of judicial review over that decision of the collective belief has to be something which is supposed to be eschewed.
Well, that is
because the collective belief which constitutes this.
Yes.
Who are we to go and question that? You have to leave it to the wisdom of the collective belief so that on that. So that, see, these are, we can take SP Mittal, we can say these are illustrative just for us to understand. But once you have a section thereof.
Your lordship, sorry, I have at the.
Otherwise, we'll be actually violating 25(1).
Exactly, my lord, that's my respectful submission. Then your lordships are taking away, it's not a privilege conferred upon.
That's correct.
It's a fundamental right given to me. My lord, ultimate, at the last, my lord, your lordships would recall the reference order says that we need to lay down the judicial policy, how to deal with these matters. And my lord, while saying that all articles in part 3 would apply, I have also said, my lord, and I'll come to that, that your lordship, I would not, my lord, argue that extreme proposition that there is no judicial review, it's ousted. That's not my argument. But it would be very, very, very restrictive, and the constitutional meaning of arbitrariness under section Article 14 would not be the test while deciding, because we are dealing with religion, and religion may not have at times any causal connection. Lord, for example,
You're right, because the word religion is found between Articles 14 and 24 only in Article 15(1).
Yes.
Against the state. 15(2), you may say it's a horizontal right, and 16(5) is where they say religious denomination. Except these three articles, the word religion is not found in Articles 14 to 24.
I'm grateful, my lord.
Then, subject to other parts of part 3 must be only on the plane of religion and nothing else. If any article does not deal with religion, how can you make a fundamental right to religion subject to some other article which is totally foreign to it? That is what we are looking at.
Lord,
Please develop the argument on that.
Lord, the difficulty is Article
There's
16.
no difficulty there.
Article 16.
Yes.
Mr.
No,
Mehta,
it is different.
Mr. Mehta,
I know that.
Mr. Mehta.
See, Article 17, etc. would come into play insofar as the state is concerned for reforms under 25(2). But you can't say that the right under 25(1) is subject to Article 17.
No.
Article 17 does not deal with religion.
Exactly, my lord.
It's with untouchability.
Even in my house, I cannot violate 17.
Therefore, you can bring in as a social reform under 25(2), the state can bring in. But that is different from saying that Article 25(1) is subject to Article 14, 15, 16, 17, 18 like that.
Yes, yes, yes.
5 it is subject to. And Article 25(1) is subject to the other parts, means it is subject to 26 to 28. And Mr. Gopal Shankar Narayan has also said 29 and 30 because the word religion finds a place there. In no other article.
No, no, but my argument,
So you have to say subject to means, how do you interpret subject? It has to be when it is on the same subject. Subject in the sense, not subject to.
subject to, the same subject matter.
Otherwise, it becomes chalk and cheese.
Lord, my argument is based on a demurrer that
Article 14 applies when you are dealing with Article 25(1), right?
it would, my lord, because 25 would obviously, my lord, apply.
Can you say Article 25(1) is subject to Article 14? Article 14 is against the state.
Yes, yes, my lord, not against,
But this is something individual.
but that is where, my lord, the arguments of horizontal rights and vertical rights would come. My lord, my argument, let me make myself clear, is on a demurrer that even if your lordships were to apply any of the
Won't be able to reconcile subject to other parts of Part 3 unless you relate it only to the word religion, which is there only in Article 15(1).
and 60.
No discrimination on the ground of.
I'm grateful. That's a new point, my lord.
Two, it may be horizontal because bathing guards, etc. against others. 16(5). 16(5) will apply as against 25(1) and 26 because it says only person belonging to that religion can be appointed as an incumbent of an office of a particular religion. 16(5), that is an exception to 16(1). 16(2) also has the word religion. But they are all on different planes.
Lord, as I understand, my lord.
Article 25(1), which is conscience. If we start mixing up all like this, then there will be no religion in this country.
My lord, as I understand, my lord, the proposition would be that the fundamental rights which affects the religion or religious practice in Part 3 would apply to 26. That's, my lord, that's the only way we can, my lord, reconcile. Now, my lord.
That is the reason why 26 does not have the phrase subject to other parts of Part 3.
Lord, I didn't think it, my lord, in that. Ladyship is right, my lord.
Mr. Mehta, if we've understood you correctly. No. We've understood you correctly. You said that because we are reverting to fact, though we should not go to that Ayyappan's can be taken as section or a denomination itself. Or
Denomination or section thereof.
So you would qualify it as a denomination or a section thereof?
It is a denomination according to me, but even if it worst scenario, it is a section of a denomination.
No, because can we give the definition or can we make the definition term applicable to this particular Ayyappan for that particular temple for the reason that the denomination means you have a religious belief, but some difference from the main. From the main body, you have some difference, maybe because of rituals, custom, practice, or a little bit variation with that. But then for a 2 or 3 year period in a year, if that is only applicable, can it become a denomination per se as by itself? Because it is only limited to a few days in a year. A denomination shall have to have a continuing faith and all. Section thereof, or would you want to put it in a section so that it is more broad? That because that a denomination has a section which is Ayyappan, and that Ayyappan section for that limited purpose, for something it has an institution, and for a limited period it has some particular rituals which have to be followed. Or per se it is straight away denomination.
May I answer? My lord, my case is Ayyappan's is a separate independent denomination also. My lord, in the Indian scheme of internal plurality, there can be an overlap between one denomination and another. For example, Vaishnavites is a denomination, Madhavacharya sect is also a denomination, Both follow substantially the same rituals. The theory, the doctrinal policies, etc., may slightly differ. So both, I can be a member of both
You
denominations.
can take Sabrimala itself.
Yes.
Sabrimala is the only place where the women are not allowed. In other Ayyappan temples are allowed. Therefore,
1,000,
it forms a separate denomination.
exactly, my lord.
No, but the other temples are also Ayyappan.
No, my lord. Only those who go to Sabrimala are Ayyappans.
That's why the expression is denomination or section.
Section.
There is no complication in
That's
here.
correct. Actually. We don't want to get involved in this thing. Let's leave it at that's contained under 15(1).
Don't belong to any.
That's not the role of the court.
Section means of
Fine.
deviation, some kind of.
My lord, my submission is this.
Uniqueness as compared to the principal denomination.
It is a denomination, but at the worst, it is a section of a denomination. I am, my lord, for example, Vaishnavites, if we go to Tirupati, the Tirupati is by itself a denomination. I can be a member of two denominations, my lord. There would be overlap. There is no state.
Member of any number of denomination.
Yes.
Only thing is, if you go there, you are part of the denomination, therefore you are part of the rituals there.
Exactly.
Our belief may be common, that's where they may be the mistake. But there will be some different between the practice and rituals. But you are bound by it. Once you go there, you become part of that. You can be a part of number of denominations. But go there, common belief is there. Common belief include practice and the actual belief.
Even the way of worship, as
That's
per
what
the
it is, way of worship.
nature of worship.
Like you go to temple, each temple will have a different way of worship.
Different
So
way of worship,
you-
the
that-
attire
that-
will be different,
that
etc.
It's not open to you to get into that. You go there, be a part of it and come back.
Yes. And there can be an overlap between two
that's
or more denominations. My lord, then, my lord, there was a question of, my lord, reforms. My lord, it fell from my lord Justice Bagchi that can the court not go into the question where there is something startling pointed out like witchcraft. Lord, my respectful submission is, and I have given the list. Lord, the legislature is always conscious of some of the evil things going on in the society and the legislature. Lord, first of all, the religion reforms itself from within. That's the beauty of all our religions. We reform ourselves, my lord. As her ladyship rightly said yesterday, sati was not a religious practice. It was a social evil. But we could reform ourselves. But the question would be, can the court function as a reformer of religion? My respectful and unapologetic answer is no. And the reason is this: the constitutional scheme entrusts, and very wisely, advisedly, and very consciously, the reform part to the competent legislature, and there is a reason why. But whenever a particular practice is required to be reformed or some act of social measure, as
So there, please explain, it says law. 25(2) says law. Now, if you rely upon Article 13, law includes all other.
even notifications, etc.
So can we take it from your submission that to invoke 25(2)(b), it's a, when you make a reference to law, it's a legislative act.
Need not be, my lord. It is law as understood in 30.
That's correct.
It can be by way of rules, regulations.
We can take it, it's a policy.
Yes, my lord. Government
Policy
ordinances,
decision we can take.
notifications, etc.
We can take it as a policy decision. We can take it as a policy decision.
Absolutely.
Yeah, that's correct.
Can be by a notification.
144 orders are being passed, my lords. And in case of, my lord, some drastic reform, Lord, it is generally preferable to have law. The reason being, Lord, before passing of a law, there is a detailed practice. In, my lord, one of the matters, my lord, I had shown the proceeding of the select committee, where they invite experts. The members of the parliament or the legislature, they sit, they invite experts from various fields. There is consultative process. Because what is law, my lord? Law, I am also present in parliament through my representative. Each and every citizen of this country is present in parliament and in case of state through their representatives. Lord, when a law is passed, it is acceptability is much more, my lord, than a judicial verdict. I don't wish to, my lord, compare this with Sabrimala, but its acceptability is much more, and therefore, advisedly, the parliament has left reform to the my lord, the state. And please see, my lord, some of
Mr. Solicitor, my contention was not reform per se, but ultra vires. Religious affair management may fall foul of public order, morality, or public health.
Certainly,
In
your
these
lordship.
situations, if it is brought to the notice of this court in an undisputed fact situation, the courts have the not only the right, the
But the
constitutional duty
I
to
bow.
declare it ultra
Not,
vires.
in other words, if I have understood my lord's query correctly,
But
if
when
a,
it comes to incremental change, which may reach to a constitutional ideal, courts would naturally defer. Like in umpteen number of times, the courts have urged the parliament to invoke Article 44 of the Constitution.
Lord,
But the courts have never said issued a mandamus because the courts can never issue a
mandamus
mandamus
to
to make a
Parliament.
law.
Lord, in other words, my lord, I think we are, my lord, on the same page.
Exactly.
If a practice comes before your lordships which falls within, which is contrary to public order, health, morality, or, my lord, any of the prohibited zones, then your lordships can certainly exercise the power of judicial review, but not as a part of reform. If it is otherwise not falling within the prescribed.
Whether this principle can be extended to other parts of the other articles of part 3 also. You say public order, morality and health, you are saying, then court can interfere. Now, what about the other part?
Reformist role, my lord, I am only on the reformist.
I'm asking you, see, you are trying to segregate, as my brother has put it. One is the power under the 25(2)(b), which is exclusive domain. The other is the prohibition to a right under 25(1) is a restrictive prohibition subject to public order, morality, or the other provision of part 3. You said about subject public order, morality and health. What about the other part?
My lord, other part except
To
those
apply
parts.
that, then you have to concede to this also.
No, my lord, all other parts
Yes.
where there is a reference of religion, my lord, would be applicable. But that also, your my lord, I am going to say
Amount to striking down a religious practice.
practice which is impermissible. That's
Court cannot do in a PIL or in a.
even affected party cannot.
But Mr. Mehta, the
If
moment
there
it
is a
says,
legislation, the validity of it can be questioned by the aggrieved party. Then the court will consider the validity of that legislation in the context of Article 25 and 26 and other articles. But the court cannot, in a writ petition, strike down a religious practice or a custom by saying
Not
it is
supported by law.
antithetical to the other parts.
Cannot, my lord.
That itself is the
Even
erroneous
if-
approach.
Lord, I have also.
One, whether the court can entertain it is one, and secondly, by whether it can say that this is contrary to the other provisions of
my lord,
part 3 and strike it down. That is also the
my
basic
understanding is
wrong thing.
mere practice unsupported by legislation cannot be interfered with. And even if there is a legislation either permitting that practice or prohibiting that practice comes before the honorable court, Lord, the judicial review and its scope would be very, very restricted because this court is not equipped, Lord, in the sense of, Lord, the subject matter with the religious text. Because if the court requires to examine the scriptures, etc., to come to a conclusion whether this is a practice or not, required or not, etc.
Can we put it that way? See, now, 25 says subject to two factors, no? One is public order, morality, and the other is constitution. Therefore, we can say the other second part, which refers to the other parts, other articles of the part 3, would not be available to a member of a religious denomination. It's only at the intra-dispute questioning. It may be available to on the same analogy of public order, morality. On a larger issue. And in that what you are saying is if it likely to come under interfere with your power under 25(2)(b), then probably the court should not.
Court should not. My lord, court should say that you persuade the legislation. Persuade the legislation because legislature, because the constitution has provided for a separate mechanism, and that's therefore taken away from the purview of the court.
but Mr. Mehta, even for that limited purpose, the court will have to go whether it is reformist in nature or purely cannot sustain the test of the constitution. Just because it can be labeled to be that the court is being reformist, we should not hold our hands back. Who decides?
Not
whether it
challenging
is
that,
reform?
my
No,
lord.
no.
That your lordships are holding the hand. Not, my lord, that way.
Wow. For that also the court will have to
It's a
have
legal
judicial review.
submission, my lord, not a
Judicial review has to be there.
arrogant
Then we can
submission.
come to a
That won't be-
conclusion that no, this would be falling in part of the religion and it cannot be reformist in nature. But then what you perceive as reformist, the court may take as a fundamental right of the person coming to the court.
That's the problem.
Irony
That it
is-
is something very, very subjective
No, no.
and therefore court should not do.
Mr. Sir-
Because what I perceive something, your lordships may not perceive. What your lordship may perceive, some other bench may not perceive. Therefore, it is better that the legislature decides through the people's representative.
Irony in
It
Sabrimala.
cannot be based on subjective views.
The irony in Sabrimala is that the rule recognized this religious practice, this ban. It recognized it, saying it's part of custom or whatever. That was questioned,
It could not have been,
struck down.
the judicial review against that rule should not have been exercised. That is my respectful submission.
But that submission of yours, probably it is tentatively not acceptable that we should leave it to a legislature. That means surely just because of majorityism, we cannot, we should not. Absolutely.
Majoritarianism, my lord? It's democracy, I'm sorry.
Majorityism in the sense that
It's
because-
democracy.
No, no.
Democracy means
No, no.
majority.
You linked it with that court should not. That is what is up. They may do it. They are not
Okay,
saying
my lord.
they do it.
I made my-
Cannot say the court should not do it just because the legislature has passed that order.
It's not majoritarianism which the court is bothered about.
My lord,
The court is essentially bothered about majoritarianism trumping constitutionalism.
Yes.
And that is the Lakshman Rekha. We are committed to a democracy, which is definitely a test of numbers, but we are also a constitutional democracy. So even if a majority feels that a particular thing is to be done, the courts have that role to test that decision from the constitutional principles.
That is, there
the area
cannot be any.
courts operate. It's not that the courts are either
No, Mr. Mehta,
anti-majority.
Your lordships are right. My lords are right. Let me come to another.
Majority means that the majority has passed it, we should not. That was the.
That's, my lord,
Because
maybe I was not
passed
clear.
by The majority.
Maybe
that
I was
is-
not clear to your lordship. I said directly when the practice is challenged, the court would not interfere and ask them to go before the legislature. If the legislative act is challenged, the
Mr. Solicitor, your point is
review would
well
be relevant.
taken. Your point is well taken.
We are unnecessarily debating. The question of religious practice has nothing to do with majoritarian principle or minority principle. Minorities can have their own religious practice.
Exactly, I'm grateful.
Majorities can have their own right.
Exactly.
All are protected under 25. So it's not that majority will take or minority or minority.
As a matter of fact, my lord, kindly come to know.
Everybody has that protection.
Apropos
We
that,
are only examining the extent of that protection.
apropos that, please come to page 19 of the note.
Mr. Solicitor, Article 25, 3 words, all equally freely. So if you read these in line, everyone has equal right, irrespective of the number of persons to which this right is.
No, that is the purpose of equally entitled, that irrespective of their numerical strength.
Word equally is preceded by all, followed by freely.
Freely. I'm grateful. No, therefore, equally, that whether it's a small religion, big religion, minority, majority, all are.
One-man religion.
Even one-man religion, yes, no, that can be. But please come to page 19. Lord, there has never been, these are all reform laws, and there is no majority minority issue.
25(1) is religion neutral.
Neutral, yes.
25(2) is not religion neutral because there is a conditions imposed on Hindu religion that you can't indulge in certain practices which are prohibited under 17. So
Second part of 25(2)(b), not the first part.
Not the first part.
that first part is again religion neutral.
Neutral. I am grateful. That's my submission. Please, for my satisfaction, come to 19 of the rejoinder note. Lord, I'm not again on minority, majority, but the majority has accepted all reforms. What is Hindu Marriage Act, Hindu Succession Act, minority, so and so, so and so. But interesting is, Lord, how superstition is also taken care of, and some of the ill social evils is also taken care of by the legislature. That's what I want to show. My Lord, kindly see 7 at the bottom. Gujarat Animal and Bird Sacrifices Prohibition Act. There is an act, my Lord, of legislature. This is reform under 25 2B. Next, Kerala Animal, Birds and so and so. Please have a look at, my Lord, 15 at the foot. Something interesting.
So each act is a salutary, a reformatory act.
Against witchcraft, there is an act.
Mr. Solicitor, since you are bringing up witchcraft, it was this court's direction to various state governments to make specific legislations prohibiting witchcraft.
Lordships are right.
This is where the judicial role comes in. It supplements and it encourages the legislatures towards the constitutional goal of reform.
I'm grateful.
It may not supplant it.
Even my Lord, Black Magic Prohibition Act, there are some salutary acts.
Human sacrifices were a part of.
There is a act
Yes,
prohibiting.
act prohibiting human.
Prohibiting it.
We continue after.
Yes.
Yeah.
may not. I'll just make three propositions.
Yes, yes.
Lord, page 9 is my proposition. Lord, sometimes your lordships may be confronted with a situation where the practice in question or whatever activity is in question might be an admixture of secular, economic, etc., and religious activity. Lord, the respectful submission is that your lordships in such circumstances would lean in favor of protecting religious freedom. For example, lighting a diya is a religious practice. In a particular denomination, lighting 100 diya per day can also be a part of a religious practice. But purchase of ghee would be secular practice. And suppose there is a restriction that you will not be able to purchase ghee beyond a particular point, it would be an admixture. In that example, your lordships would lean in favor of protecting the right of freedom of religion and, my lord, not the secular aspect of it. My lord, that is the proposition at page 9, and I have explained with, my lord, some judgments. I am not, my lord, reading. Then para 11 is constitutional morality, my lord, which I have addressed in page 11 in great detail. But what I have done for your lordship's convenience is, my lord, at page 12, I have given the origin of this doctrine. Lord, thereafter, I have given what Dr. Ambedkar meant by constitutional morality, means some constitutional healthy precedents to be observed by the functionaries, how the president should behave, how the governor should behave, etc. Then the most important and easy to find aspect is page 13, wherein I have given from S.P. Gupta onwards that the correct understanding of constitutional morality was adopted. Till, Lord, in NCT of Delhi, where Justice, where my Lord, the then Chief Justice used it as a test for deciding, Lord, the validity, which in my submission, Lord, is completely wrong. And thereafter, my Lord, I have given the judgments. I am not, my Lord, reading that. I have already pointed that out.
The note is also self-explanatory.
Yes, my Lord. So I am not, my Lord, troubling your lordships. My Lord, kindly come to 16, and this is the last point I am making, the judicial policy, my Lord. My Lord, one question was whether conscience would also be a part of, conscience would be more than religion or not, my Lord. My Lord, in my submission, conscience would be wider than religion. So that's the proposition, that's all, my Lord. Please see, my Lord, page 16. What should be the policy? Because your lordships are, my Lord, essentially examining and laying down the policy for the future course of action. This is my suggestion, and I'll skip what is longer. My Lord, my first is para 68, para 69, I'm sorry, para 68. The court in cases involving Article 25, Lord, page 16. Court in cases involving Article 25 and 26 must first look at whether there is a religious practice and then test it on the ground of public order, morality, and other provisions of Part 3. The court can also examine whether the practice is restricted by any law made under Article 25(2)(a) or (b). If it is not possible to decide the above referred question, that is, whether it is a religious practice and whether it affects public order, health, morality, or any other restrictions, merely based upon affidavits and arguments, the constitutional court should not be court of first instance, and the parties may be relegated to the remedy of civil suit, where not only expert witnesses can be examined, but also evidence can be led. Lord, many judgments which were cited before your lordships arose out of civil suit, first appeal, and then, my Lord, your lordships had the advantage of several, my Lord, evidence led, etc.
Article 226 was not there
Yes.
before
No, my
1950.
Lord. No, my Lord.
Government of India Act did not have anything like 226.
No, my
That
Lord.
is why there was no writ petition.
No, my Lord.
A suit was filed.
My Lord, after Constitution also, there is a judgment on Section 9 in the context of Article 25 and 26. My Lord, that is a judgment 1995, Supplementary 4 SCC 286. Most Reverend PMA Metropolitan and others versus Moran Marthoma and others.
Once again, the citation, 1995.
1995, Supplementary Volume 4, SCC 286. Even in after 50s, there are judgments where civil suits were filed and decrees either rejected or granted came to be challenged before the High Court, my lord. Yes. My lord, 70, my lord, I have said that while deciding whether it is a religious practice, whether it is what is morality, etc., the court would not go by nondescript authors and articles, etc. Or 71, while examining any issues concerning religious freedom, the court will not enter into the question as to whether the religious practice is essential or integral to the religion. If it is a religious practice and not proscribed by being against public order, health, morality, or fundamental rights, the citizens as well as denominations will have a fundamental right to practice it. The judicial, this is important, but judicial review in such matters. Sometimes, my lord, someone may say Article 14 is violated. Someone may say Article 21 is violated. Your lordships are dealing with religion. Article 14 would be dealing with arbitrariness. What is the nexus? What is the object and the nexus to be achieved, etc. In religious matters, sometimes it may not be possible. It may be from constitutional perspective, may not lead to any object to be achieved. But it is still a faith, it is still a belief which is protected by the preamble. And therefore, your lordship's scrutiny, in my respectful submission, would not be the constitutional understanding of Article 14 or Article 21 or any other article, but from the point of view of a person who follows the religion and he has a belief system which is protected by the Constitution. So it would not be discrimination and therefore set aside. It will have to be dependent upon several factors, including the belief system and other, my lord, factors which are already pointed out to your lordships. And constitutional morality, your lordships may specifically declare, that's my humble prayer, that is not a test for deciding either a legislature's competence, a legislature to be constitutionally valid, or any other executive or other order. No, that is something, my lord, which has crept in somewhere, my lord, which was never intended to be a test for invalidation. My lord, in page 17, line 2, there is one word typographically missing, cannot be tested. My lord, if your lordships can. So, page 17, para 72, second line, arbitrariness or irrationality as per religious faith and belief cannot be tested. It should be not is missing. Yes, not is missing, my lord. It's a typo. Well, last, I'm not arguing, my lord, but some of my friends have argued issues like waqf, etc., etc. So what I have said, kindly confine to the questions involved rather than, my lord, adjudicating upon other issues. I am immensely grateful.
Thank you.
Wait, please. I have given a written submission, my lord, and I'll confine myself.
Very briefly, Mr. Vedanath.
I'm sorry.
Very briefly, Mr. Vedanath.
Well, I will take about 45 minutes to an hour.
No, please.
You, this
In rejoin.
reply.
Only the specific questions, Millard, I am dealing with, and I am not confining my, going beyond that, Millard. I have in my submission.
We thought 4.5 minutes.
I'm sorry.
We thought 4.5 minutes.
Millard, I wish I could do it, Millard, but I am not as precise as my lords are. I am not. Millard, I will be brief.
Please, very briefly, otherwise we will read the note. You can just point out that.
Yes, I'm going to deal with. Millard, the first aspect is, in my respectful submission, some of the persons who have argued have proceeded on the basis that Article 25 and 26 have for the first time conferred certain rights either on the individuals or on the denominations. My first submission to is that these are part of our natural rights, pre-existing rights, pre-constitutional rights. Constitution merely recognizes these rights. And that is, Millard, a well-settled proposition. A series of judgments including Golaknath, the various other judgments. I have referred to them. I have given a separate note in regard to it. I don't intend going into it. If my lords will kindly have a look at my page one, I'll be reading only very few lines from the submission. But the first and second paragraph are important in this context. Kindly have a look at that. India as a civilization has sustained ordered social life not through the command of a sovereign or the decree of a legislator, but through dharma, a concept that has held its diverse communities together across centuries of coexistence. As Chhatrapati Singh demonstrates in his seminal work, the idea of law, properly understood, is the idea of dharma. Dharma is the external, non-coercive moral order which holds the community together and leads towards a moral ideal. Then, beloved, I come to the last sentence of that paragraph. Law as dharma is the only basis on which a cooperative and peaceful international kinship can be established. If the idea of law is the idea of dharma, and if dharma is prior to and independent of the state, then the rights that flow from it, the freedom of conscience, the right to profess and practice religion, the right of a religious community to manage its own affairs in matters of faith, are not creations or gifts of the Constitution. They are pre-existing entitlements or rights inherent to the individual and the community respectively, that the constitutional text acknowledges, protects, and regulates, subject to stated restrictions. It is the restriction that has been brought in 25 or 26, subject to public order, morality, etc. The right is pre-existing. It is the restriction. What kind of restriction there can be is what is brought in 25 and 26. It's on this foundation that Articles 25 and 26 must be read. Articles 25, 26 do not confer rights, they recognize them. Now, I have referred to Golaknath, Nagaraj, etc., which accept that these are pre-existing rights. The fundamental rights are not conferred for the first time. They are natural rights, pre-existing rights. I refer to those judgments. I am not reading that ADM, Debel, Puttaswamy, all those. Then, I come to para 5. The textual structure confirms this. Article 25(1) provides that all persons are equally entitled to freedom of conscience. Article 26 provides that every religious denomination shall have the right. The language is of entitlement and recognition, not of grant or conferral. Further, then, I come to para 7. I omit Coelho. The judgment is well known, and whatever is necessary to be read, I have extracted. Articles 25 and 26 occupy distinct. This is my respectful submission for my Lord's consideration. Article 25 and 26 occupy distinct and independent constitutional spheres. Article 25 is an individual right. It protects each person's freedom of conscience and right to profess, practice, and propagate religion. 26 is a communitarian right. It protects the religious denomination's collective right to establish institutions, manage its own affairs in matters of religion, own property, and administer it. Right holders are different. Individual under Article 25, denomination under 26. Content is different. Personal religious freedom under Article 25, institutional and communal religious autonomy under Article 26. The restriction regimes differ. Article 25(1) is subject to public order, morality, health, and other provisions of Part 3. 26 is subject only to public order, morality, and health. A deliberately narrower set of restrictions, the omission of and to the other provisions of this part being as submitted in section B below, deliberate and dispositive. Neither 25 nor 26 depends on the other for existence or force, because that was the submission made on the other side. The argument was, if Article 25 was hypothetically absent, there won't be any 26 right. That was the argument. I respectfully differ from that. If Article 25 were hypothetically absent from the Constitution, 26 would still protect the denomination's right to manage its religious affairs in full. If 26 were hypothetically absent, 25 would still protect the individual's right to profess, practice, and propagate religion in full. Neither is a derivative of the other, neither is a subset of the other. Each stands on its own constitutional foundation with independent and equal force. Then, Millard, I have given some examples of independent operation, and Millard, I will only refer to Shirurmat, para 9c. In Shirurmat, this court held that the denomination has complete autonomy under Article 26b to manage its own affairs in matters of religion, and that no legislation can take away that right. The right was the denomination. No individual's Article 25 claim was an issue. Article 26 operated on its own. Para 10. It is with respect wrong to proceed on the premise that without Article 25 there would be no Article 26, or that Article 26 is merely a collective manifestation of Article 26. That premise conflates the individual with the community and the personal with the institutional. A denomination's right to manage its religious affairs is not an aggregation of its individual members' personal rights to practice religion. This is quite distinct and different. It's a distinct right vested in the denomination as a body, and it protects something qualitatively different: the community's authority over its own faith, doctrine, ritual, and governance. Shirurmat recognized this when it held that what constitutes a matter of religion is to be determined by the denomination itself. Ratilal confirmed it. The right of management in affairs of religion is a guaranteed fundamental right which no legislation can take away. That autonomy is the denomination. It does not flow or through Article 25. It does not flow from or through Article 25. Because Article 25 and 26 operate in independent spheres, there is no need for harmonious construction between them. Harmonious construction presupposes a conflict between two provisions that compete in the same constitutional space, 25 and 26.
Take us to the line.
Yes, I'll answer. My respectful submission is, there are three situations where there can be, 25, an individual asserts that what the denomination is doing is not right. Right to profess or practice religion under Article 25. Please imagine like a raga. Raga has certain notes. Each individual can do an alapana in different form, but he has to conform, he or she, the Vidwan or Vidushi, will have to conform to the basic notes. If he misses the notes, then it is either Shruti Bedam or Abashruti. It is no longer that raga. It is a different raga. It's a different religious denomination. You still have freedom under Article 25 because you have to comply with the basic notes. You can't go beyond the notes. You can't say that it's not Suddhamadhyamam, but it's different. Then it becomes a different rag. Therefore, that you have, this is the extent of freedom that each individual has. Now,
You are trying to say it will be an apashruti.
yes, it will be therefore that can't be. You can play, you can have a different raga. Therefore, it is not necessary that everybody should sing only Ananda Bhairavi. You may have Shankarabharanam. You can have a different raga. Therefore, that is the difference. That's the freedom that's given. If I come back to para 12, fifth line, the individual cannot, under Article 25, claim a right to worship at a denominational institution in a manner that overrides the denomination's Article 26b right to prescribe the mode and conditions of worship. Nor can the denomination under Article 26 extinguish the individual's Article 25 right to profess and practice religion in his personal capacity. The two do not collide, they coexist. I then come to the last 4 lines of the paragraph. It is not a right to enter any denomination institution.
You have already well explained these are all principles.
I'm sorry?
You have already well explained these
No
principles.
need for repeating.
Yes, very well. No, then I'll skip this part now. I'll go straight away to paragraph 14. I have already said the independent, pre-existing, independent and co-equal fundamental, each self-sufficient, each operating its own sphere, each subject only to restrictions expressly stated in its own thing. Then Millard, B, Millard, I want to read only the paragraph 17. Millard, paragraph 15, my lords are well aware, Millard, Article 26 does not make it subject to other provisions. 25(2)(b) is only an enabling provision. It is not an independent right. These two cannot be equated. And 25(2)(b) contains 3 distinct enabling powers. 1, regulating secular activities associated with religious practice. 2, providing for social welfare and reform. And it is only the third which is dealing with Hindu public institutions. 1 and 2 is applicable to all. 3 alone is confined to Hindu public institutions. Third limb applies only to so and so. And Millard, social welfare and reform does not mean reformation of religion. Now, Millard, in subheading C, my respectful submission, which I want to reiterate, Devaru, in my respectful submission, the reasoning is incorrect. Conclusion may be right, but the reasoning is incorrect, and I have given the reason. Decision is confined to the facts. A temple found on concurrent findings to be a public character. It was found to be a denominational institution. It was found to be a public character, both in the civil suit. In that context, the question was whether exclusion of Harijans was right, and this court held that no, it is not. Court applied harmonious construction, which in my respectful submission was unnecessary. Because according to me, Millard, paragraph 22 and 23, an institution may simultaneously be denominational and of a public character within Article 25(2)(b). Where a denomination has by public dedication brought its temple within the public domain, the application of throwing open legislation follows from the act of dedication, as the Venkatramana temple was found to have been. It is not that Article 25(2)(b) overrides Article 26(b). It is that the denomination has itself relinquished exclusivity. The conclusion in Devaru may be supportable on those facts. The reasoning is not. Devaru should be overruled on 3 independent grounds. First, the phrase "nothing in this article" confines Article 25(2)(b) to Article 25 alone. Devaru did not address this. Second, the conclusion that Article 25(2)(b) overrides Article 26(b) is per incurium of Shirur Mutt and Ratilal, both which are not overruled or distinguished, could not have been overruled because it was a smaller bench, both of which held that 26(b) cannot be abridged by any legislation. Devaru itself considered this before holding to the contrary. Third, the interpretation discriminates against Hindu denomination. This is also important because 26 protects every religious denomination, Hindu, Muslim, Christian, Parsi. But 25(2)(b) applies only to Hindu religious institution. If Devaru is correct, Hindu denominations hold a constitutionally weaker 26(b) right than every other denomination in India. The Constitution does not permit any such discrimination between faiths which it seeks to protect.
The context of entry, in temple entry.
Yes, temple entry because it was a public temple.
Not deal with any other affair of
That's
religion.
right. That is true. But in
The
regard to
narrow
temple,
issue was temple entry.
correct.
And there was no, the facts were that they did not refuse anybody else entry into the temple.
Correct.
Therefore, they said 25(2)(b) will be applicable to
25(2)(b),
people of all sections and classes.
25(2)(b) will apply on its own force because it was a public institution. public temple. Therefore, it was not necessary to take into account 26B, right? Because
So
26B,
was
a
the
religious
contention.
denomination,
They had to answer the contention. which
with
was
the
raised.
greatest respect, once it was declared to be a public institution, then you can't assert your right to under 26B to prevail over 25(2)B. That's my respectful submission. Then, the ERP doctrine, it's very important. My respectful submission, which I wish to reiterate, what Shirur Mutt said was not of the practice having to be essential to the religion. That was not the test laid down. That was not even, Attorney General might have argued that, but that was not adopted as a test by Shirur Mutt. Para 26 and 27, misreading is essential part of a religion, meaning what constitutes the religion from the religion's own perspective, was transformed in subsequent decision into essential to religion, meaning what the court considers as indispensable. Once that shift occurred, the court became the arbiter of what a religion requires. This, I respectfully submit, was never intended. It replaces a test of religious identity with a test of essentiality and transfers constitutional authority from the denomination to the court without textual warrant. Once a practice is found to be religious, it falls within 26B. Court has no mandate to evaluate its importance, rationality, or contemporary acceptability. To do so is to apply the ERP doctrine, which has no constitutional foundation. Denomination's authority over its own faith is on the holding of Shirur Mutt complete. The case-by-case trajectory of this transformation that I have set out in last page, Annexure C, how from Shirur Mutt, Dargah Committee, Tilkayat, Shastri Yagna Purushasji, and Acharya Jagdishwaranand, this essential religious practices has changed. That transformation, I respectfully submit, was completely unwarranted and on an erroneous interpretation of Shirur Mutt. Now, what constitutes a religious denomination? I respectfully submit Constitution does not require a minimum number of adherents, para 30. No, there is no need for a formal organization. No distinctive name is required. Shirur Mutt did not lay down any three-pronged test for determining a denomination. It referred to the Oxford Dictionary, but it did not lay down any such test. Well, SP Mittal, in my respectful submission, wrongly construed Shirur Mutt as laying down the three tests. And I have argued already on Dharmic Sampradaya that the respondent submitted that how can you take the Hindi definition that's not authoritative, English version. If Oxford Dictionary definition can be referred to for interpreting, according to me, the Hindi version of the Constitution, which has been adopted by the Constituent Assembly, members of the Constituent Assembly, can certainly be looked at to interpret what was the intent behind this use of the expression religious denomination. Otherwise, it will be giving no importance or meaning to that. I have already said Sampradaya derives its identity from a shared faith, belief, and practice, and community bound by common lineage. I am not referring to it. Now, one of the questions that my Lord Justice Sundaresh asked, is a religious denomination a juristic person? Article 26 recognizes the right in the religious.
That's not my question.
I'm sorry?
My question is, if the religious denomination is a person under Article 25(1).
Wait.
Juristic person, I don't think there is.
Juristic,
there is no.
yes, juristic, yes, it may not be necessary, but I have said it is not necessary to have, today, in Ayodhya case, my lords have recognized the idol, but that is based on the old Pramathanath Malik and line of cases. And my lords also went into the question of a ship, how it is recognized as a juridical person for the purpose of identity. Now, in my respectful submission, Constitution recognizes that a denomination can have the right, and I have dealt with that since my lords feel I am not reading it. Now, this G is very important, page 8. This is very, very, and I have been, I must acknowledge that I have been interacting with the senior President, Mr. President, and his main, one of the important concerns that he has expressed was in regard to the muds. And it's in that context, G, I have specifically incorporated. And I must say that Mr. Parasaran has been watching these proceedings every day and has been interacting with me, and he has been it's in that context, specifically, I have put this in. A mutt operates on Guru Sishya Parampara, the transmission of religious knowledge and authority from initiated teacher to initiated disciple. Entry is conditioned on initiation and acceptance of the mutt's discipline. The discipline is the management of religious affairs under Article 26B. It cannot be regulated by legislation. A mutt is not a religious institution of a public character within Article 25(2)B. That provision has no application to it. Where a mutt and a temple coexist, it happens in Sringeri, it happens in Kanchi, it happens in Ahobilam, all these places. But mutt is separate, temple is a temple, public access, it is a public temple, 25(2)B may apply. But in regard to a mutt, it is private, 25(2)B cannot be invoked. Where a mutt and temple coexist within the same premises, not uncommon, each retains its own constitutional character. The same premises may contain both public and private religious places. A public temple within the complex may be subject to Article 25(2)B. The mutt's restricted premises are governed by Article 26(B) alone. Permissive entry does not convert a private temple into a public one. As this court noted in Devaru, it would not in general be consonant with the Hindu sentiment to turn worshippers away. That grace does not change the nature of the dedication. Family temples, community temples, and temples consecrated for the worship of a deity in accordance with the specific denomination's agamic prescription retain their private character under Article 26B right to determine the conditions of entry. 17 abolishes untouchability. Its operation presupposes exclusion from a public institution. In regard to public institution, it applies. Now, on Archaka appointment, I had already submitted Seshamal, and is incorrect. Seshamal and Adityan are incorrect. And I just want to read 2 or 3 sentences, para 43, last 3 lines. The act of worship and the person who performs it are constitutively connected in the agamic framework. To hold that the act is religious, but the appointment is secular, is to divide what the agama treats as indivisible. Then in para 44, I deal with this part of Seshamal where it says the trustees can appoint. But the trustee is under the control of the HRNC department. Therefore, HRNC department effectively controls. Therefore, that, in my respectful submission, will be, you can't do that. That is taking away the right from the denomination. Then, para 45, the distinction between caste-based exclusion, impermissible under Articles 14, 15, 16, and 17, and denominational agamic qualification protected under 26B and 16.5. 16.5 expressly talks of this, is constitutionally clear. Adi Shaiva correctly drew it, Adityan did not. Seshamal requires overruling to the extent it classifies Archaka appointment as secular. Adityan requires overruling to the extent it conflates caste-based exclusion with agamic denominational qualification. Adisaiva requires clarification that its holding is categorical. It does not require fact-by-fact adjudication and does not support the broader proposition. Then, on judicial review, I have drawn 3 categories. In what circumstances court can interfere? A petition by a non-adherent to challenge the denomination's religious practices in my respectful submission, he has no right. A person who is not part of the denomination, non-adherent. Second, a petition by a non-adherent, but Millard espousing the adherent's rights because he is not in a position, like for example, some tribals. It could happen. Then in such an event, maybe a public interest petition may be entertainable. A third, a petition by a dissenter within the denomination, Millard, this is completely barred. Millard, that cannot be. Millard, I have made those three different classifications in para 48. Now, Millard, I come to the correct for in case of horizontal disputes like this, Millard, the correct form will be the Civil Code, Section 9, Section 92, and Millard read with Section 48 and 49 Evidence Act. And Millard, that's where it has always been decided. Malankara disputes to which the solicitor made a reference, Millard, it has been decided like Jacobite and Orthodox churches. Millard, Shwetambar, Digambar, those disputes have been decided. Millard, that civil courts can do. Yes, yes, Venkatramana also. Therefore, Millard, those are aspects, but even there, it is not the theological correctness which is decided either by the civil court or by the writ court. Theological correctness is something which is outside the scope. That's a submission. Then, reference has been repeatedly made to 14, 15, 19, and 21. I have made a chart for my Lord's convenience. Page 23. I have analyzed all the articles in part 3. Article 14 onwards. And Millard, as to what is the right, what is the nature of the right, whether it is pre-existing or conferred for the first time, and what is the constitutional duty or the limitation, and whether it is horizontal or vertical. Millard, I have made a chart, Millard, which my lords may find it useful. I am not going to take my lords through that, but my submission on this at page 11, Millard, para 53. 14 and 15 run against the state. A denomination managing access to its own place of worship is not the state. 15 to addresses shops, restaurants, hotels, places of public entertainment, and roads, tanks, and places. I mean, he doesn't mention temples. He doesn't mention muds. 15:2 specifically has excluded, has not made a reference to it. And another important thing, the solicitor made a reference to Article 29. I have dealt with it in a separate note in my first submission. Well, 29 did not refer to sex or gender because in India, it's well known that not all education institutions are co-educational. Some institutions are only for boys, some institutions are only for girls. Nobody can say that even the institution is only for girls, no, a boy, should get admitted to that. That is why Article 29 is carefully drafted. It does not include gender, sex. Nobody can say that I am being excluded on the ground of sex, I must be given admission in that. Kindly keep that in mind because we can't conflate these concepts. Similarly, in 25(2), sex and gender is not enumerated for a good reason. It could have been included. It has been included in various other provisions. But why was it not included in the very same constitutional scheme? I respectfully submit because the constitution makers were well aware of the fact that there are certain aspects in regard to religion where sex and gender, there could be some distinction. Yes, yes. Subject, as my learned friend says, subject to part 3 is left out in Article 26 for the same reason. And Article 21.
In the pre-lunch session, this table is helpful to give a bird's eye view.
Yes.
Pre-lunch session, what we said is, you juxtapose Article 25
yes.
with Article 14 to 24.
Yes.
When you juxtapose it, Articles 14 to 24 does not speak of religion.
Correct.
Discrimination on the basis of religion is proscribed. But the theme of those articles are not religion.
That's right.
25 onwards up to
yes.
28 is religion.
Yes.
Therefore, if you want to exercise your rights under Article 25(1), that is subject to Article 26 to 28.
There I may have a
Is
slight
subject to.
difference.
That means
Hmm.
26 to 28 will override.
Yes, it will,
26
but
to
will,
28 will override 25(1).
yes, it will.
But
Hmm.
the matter doesn't end there.
Hmm.
Articles 14 to 24 have their separate themes.
Hmm.
In order to achieve those goals or to ensure fundamental rights there, and you bring it under Article 25(2), which enables the state to make laws. That is where under 25(2), social reform, throwing open of the temples to all sections and classes of Hindus, because untouchability is declared to be an offense under 17.
Hmm.
So you have to bring 14 to 24 under 25.
Correct. No, broadly, I agree with that. No, I have only one reservation.
28 to override 25.
Yes, no, I have only one reservation.
It
Yes,
will be
for
other-
example, if we say,
Reconcile all this.
yes, if we say Article 25(1) is only in respect of other fundamental rights concerning religion, there could be a problem. The reason is, take for example, a person who claims,
What I said is there is no religion as stated under Article 25, a theme. Freedom of religion is not guaranteed under Articles 14 to 25.
that's right. That my lord is absolutely right. My lord is absolutely right. My lord, I have no, my lord, I'm only saying, if a situation arises where somebody claiming a right to profess and practice religion says, I'll speak of certain things which are not quite patriotic, which may relate to secession. I think it's a matter where the restriction contemplated even under Article 19(1)(a), freedom of speech, reasonable restriction, that restriction can be applied even in such a sentiment.
19.2.
Yes, therefore, 19.2, although it doesn't speak of religion as such, 25(1) will be subject to that, is all that I'm saying. 25(1) will still be subject to that. That's a submission. Yes, yes. Then I come, broadly, I have the
Last point we have seen.
last one is about the apprehension that my lords had expressed during the course of my argument, that it might affect the broader Hindu religious landscape. My respectful submission is, vast majority of Hindu temples are public temples. Nothing in these temples will affect them. It's only a few institutions which could be, or much, which could be private, and where 25(2)(b) may not apply. Therefore, in my respectful submission, broadly, there won't be any effect. I am very, very grateful, but I want to take 2 minutes. I want to take 2 minutes. One, I want to recognize the contribution made by my juniors, Ronak, Vinayak, Akshay Nagarajan, apart from my advocates on record, Mohan and Yogeshwaran. Second, I want to express my gratitude, not only mine, but on behalf of the bar. My lords have given a very patient hearing to all, and we are deeply grateful.
Thank you, Mr. Vaidyanathan. Of course, without the quality assistance of the young team, becomes very difficult.
That's right.
And
Grateful.
we are also witnessing exceptional talent from the young lawyers.
Yes.
It's really heartening.
Bar has a very bright future. This we can
That makes us really happy.
proudly pronounce.
On a complex matter.
In fact, it's impossible without them. Quite frankly, it's impossible without that kind of. Whereas I will be very pointed. I have the note here. I won't read all of it. As it's being handed over, Mills. As it's being handed over, just a few prefatory comments. Just a few prefatory comments. You give copies, did you? One is, Mills, that the structure I followed is, I've taken issue 1, issue 2, all the way to issue 7. Under each issue, I have broadly, Mills, put 7, 8, 5, 6 questions / comments by my lordships related to that issue and given the transcript reference. Now, it doesn't mean that one of your lordships asked the question, another of your lordships also asked it. So I've given only a sample. And on so-and-so date, your lordship put that question. Then I've answered each of those 6 or 7 questions under that first issue. Then I've gone to the second issue, again clubbed your lordship's question, answered them. These are mostly conclusions. I'm not going to argue with reasoning. Many of these things, the reasons and the material is given in my original submissions, which I reiterate. Your Lordship, whenever Your Lordship reads it, should have both together. It is not, Malas, a repetition. I also want to say, Malas, that of course all good things must end. Malas, the Lordship was given extraordinary patient hearing. But Malas, this is issue of nuance. When 9 judges sit to decide 7 issues, there is no this side and that side. That's the one thing we have to understand. The lighter vein was when 5 lawyers sit together, Lordship has 10 opinions. When 5 lawyers sit together on religious issues, the Lordship may have 25 opinions. So therefore, there may be some issues on which I seem in the middle or maybe a little bit that side and vice versa. But it's really Your Lordship's looking at the issue-wise disposition which matters. There can't be a black and white, the highly nuanced field. Having said those preliminary points, let me come straight away. Come to issue 1 on the first page. Now, the questions by my lords are important because not only are they questions I'm attempting to answer, but they also have answers inbuilt in Your Lordship's question. So I'll just read those questions and I'll skip some parts. Principal questions posed. Justice Nagaratna questioned the relevance of the essential religious practices test, observing that much of the controversy in Sabarimala arises from that test, and queried whether the court can determine what is essential and non-essential. The query was echoed by Justice Sundaresh, who further queried whether the essential religious practice test operates as a restriction under 25(1) or as a protective measure in the context of 25(2)(a) and 2(b). I've given the transcript page also, but I mean, it's many other judges have asked that. I'm just giving a sample. Your Lordship put a slightly different nuance to it, Justice Sundaresh. Your Lordship asked the main question. Second question, whether social reform is a universal concept applicable to all religions, whereas the Constitution expressly limits the throwing open only to Hindus, and whether a universal power can be merged with a strictly limited one. I believe Justice Amanullah put that, amongst others. Whether the right to freedom of religion can be elevated to the same pedestal as 19 and 21. And that's an important issue, Malas. Golden triangle becomes a golden quadrangle or a quadrilateral. Both Your Lordships asked that question, Malas. Does 25(1) confer an independent right to enter a temple or merely recognizes a pre-existing right? This is a very interesting question of the Chief Justice, Malas. I'm going to harken Your Lordship back to Golaknath, which in fact held all the articles unamendable in part 3, principally on this basis, and was overruled by Keshwananda. Whether a worshipper, E for England, where a worshipper can reject that restriction flowing from the deity's character or tradition, and whether a restriction which is part of the philosophy of the idol is a matter of religion. Now, I've taken one by one each of these and given my submissions. So the first one is 1A, which your question is up there, was A in the beginning, about essential practices. Now, this doesn't need to detain Your Lordships. There is a large degree of unanimity that essentiality is now invalid or a confusing or an inapplicable or an unsustainable test. At least I think so. A large number of us also have, some people on that side also, maybe 1 or 2 exceptions, but large number on that side also feels that way. I'll just read 3 paras or 4 of this. Second para, 1.2.2. To superimpose a judicial inquiry into whether a religious practice is essential or integral is to insert into 25(1) a 5th non-textual ground of restriction, which the framers did not enact. 25(1) expressly subjects the freedom of conscience and the right to only these heads, and the religious practices test impermissibly adds to that exhaustive list. Whereas it's contrary to Shirur Mat. I will not read it. Your Lordship has seen, I've given the para in the footnote. Not only does Shirur Mat doesn't say what is said to have said, but it is contrary to Shirur Mat. I've given the para. Now, Justice Sundaresh's nuance about protective, I've answered it 1.2.4 to the best of my ability. Nor can the essential religious practices test be defended as a protective mechanism under A or B. A concerns the state's power to regulate or restrict economic, financial, political, or other secular activities. B concerns laws providing for social welfare and reform and of throwing open. These clauses are enabling and saving provisions. These do not define contract or condition. They do not define, there should be a comma there, contract or condition the primary right under 25(1). They say where there are 5 laws, this is wrongly typed here. That should have been in the opening. Just kindly cut off that last sentence, Malas. There's a typo there. Then Malas, 1.2.5. The denomination with reference to its own doctrines, history, tenets and practices must determine what is religious and what is secular. Your lordship's role is confined to a limited factual ascertainment, whether the asserted belief is genuinely and conscientiously held by the community or denomination as part of its religion. Once that threshold is satisfied, interference is not permissible except on the grounds given. Then, Malas, the second, social reform and the throwing open clause. That's your lordship's second query in 1.3, dealing with 1.1b. Now, Malas, social reform and throwing open clause. These two limbs, I'm reading the second parameters. These two, there are two limbs, Malas. Well, we have seen the two limbs, your lordship's textually seen there are two limbs. My submission is these two limbs cannot be conflated. The first limb is general in formulation. The second limb is textually and deliberately confined to Hindu religious institution of a public character. The Constitution, therefore, does not permit every exercise of the social reform power to be treated as though it carries with it the general throwing open mandate across religions. Equally, the Hindu-specific throwing open clause cannot be universalized across religions. A bare reading of this text of B, that is 25(2)B, demonstrates a conscious choice to single out Hindu public religious institutions in the latter limb, in view of the entrenched practice of caste-based exclusion in that context. That specific constitutional design cannot be erased by merging what is said to be universal language of social welfare and reform with the limited and targeted language of the second limb, throwing open. That's what is the interpretation of that. Further, Malas, 25(2)B, whether in general or Hindu specific limb, cannot be read to extinguish the core of 25(1) or 26(B). This, Malas, has been dealt with in my original written submissions. The footnote is there. In fact, Devaru also, Malas, says that you cannot extinguish it, etc. Then, Malas, C, the golden triangle, because I believe it would be right to call it the golden quadrangle. The expression golden triangle is commonly used for 14, 19, and 21. There is no constitutional impediment as a matter of principle to recognizing that freedom of religion occupies an equally high constitutional status and is central to the lived constitutional identity. The freedom of conscience and the right to freely profess practice are not secondary or subordinate rights. They are express, they are substantive, they are justiciable, fundamental rights. In that sense, the right to freedom of religion may appropriately be viewed as completing a broader golden quadrangle of liberty, equality, dignity, and conscience. That could be a lordship's quadrangle. However, this formulation must not be understood as creating a hierarchy of fundamental rights. The Constitution does not rank fundamental rights in rigid order. Ultimately, the approach is the same as harmonious construction. Then, Malas, the D question. Individual belief versus denominational traditions and practices. Now, Malas, this question, one question from the Chief Justice about is this given or merely recognized by the Constitution? That question has come by my Lords, Malas, in the context of 25. My answer is yes. It can't be treated as a given or a granted constitutional right. It is the recognition of an innate pre-existing right. But that should not lead to the conclusion that on that parity of reasoning, everything in part 3 is a pre-given. I have objected to that. I am saying yes to 25 and related articles like 26, but I'm not saying yes to every right. And that's the discussion I put here. It is not that 1.5.2. So the question that Chief Justice put on Honorable Chief Justice, I'm saying yes. But that was limited to 25. I'm not agreeing to the rest of part 3. It is not that several other rights of part 3 are of less importance. For example, 14 is a vital right. So also the diverse rights found in 19. There are several other constitutional rights in part 3 which are extremely important and vital. However, the importance of a right or its role in society does not necessarily, so important right doesn't mean pre-existing right which the Constitution is merely recognizing. Even within 25 to 28, large chunks are given rights, not pre-existing rights. For example, one of the Lordship's query, it doesn't take care of 26, 27, 28, they are given rights. Your Lordship is limited it rightly to 25.1. My Lord is limited to 25.1. Indeed, the conclusion that all the fundamental rights in Part 3, because they are so vital and significant, that they constitute natural rights, and consequently they are inherent and primordial for the development of the human personality, was the categorical conclusion reached by Chief Justice Subbarao, speaking for 11 judges in Malas Golaknath. And I've quoted that Golaknath passage. He actually says that virtually everything, especially 19, is a pre-existing natural right. In fact, that becomes the basis, I've said in the next para, 1.5.4. This was the basis of Golaknath holding that all of Part 3s are amendable.
Yes.
Since that stands overruled by 13 judges,
Yes.
it's an additional cautionary note that your lordships can certainly and should hold 25.1 to be part of inalienable, etc., but not the whole of it. I'll just conclude on this point on 1.5.5. Subject to the foregoing caveats, it is submitted that this court is entitled to recognize 25.1 as a natural or pre-existing right inherent in the very existence of human beings since time immemorial. To conceive of human beings cohabiting in a society which is completely bereft of religion would be to create an imaginary world. Overwhelmingly, barring individual exceptions, religion, severally and collectively, is likely to play a dispositive, important even dispositive role in society. Hence, 25.1 can rightly be treated as recognition of equality in exercising freedom of conscience and the right to freely profess, practice, and propagate. In that sense, it is an inherent and inalienable aspiration of every member of that society. Then, whereas this is that 26 versus.
Next are the issue that.
Next two are not, but I'm answering the query in the way I've answered in my original submissions. Your Lordship's query was this, I'm answering the query. Your Lordship's query clearly, yes, you must uphold individual belief, but the individual can't go like a bull in a china shop and start affecting collective beliefs. Then come to verse 2. It's actually heavier in the first 2-3 issues. The rest are simpler. The second issue is what is the interplay between the rights of persons under 25 and religious denominations under 26. Now, Lordship's questions are important. Whether there is a clear distinction between entering a temple and managing it, and whether 25(2)(b, by empowering the state to throw open public Hindu institutions, is concerned with entry and worship, rather than authorizing the state to take over the management of the denomination's internal religious affairs. Your Lordship's query and your Lordship's transcript is put there. Whether the doctrine of proportionality, as laid down in Puttaswamy, should apply to interference with rights under 25-26. Both of your Lordships asked that. Whether the limitations in 21, namely other provisions of this part and Article 25(2)(b, would be rendered nugatory if an individual professes the rights through Article 26(b). Whether harmonization and adjudication of the interplay between 25 and 26 must be done on a case-to-case basis, or whether broad principles should be laid down. Now, these are all acute questions which your Lordship will be ultimately answering this way or that way in the final judgment. So it's important to isolate the questions and answer them. These are your Lordship's concerns. Does 25(1) have the same preeminence as 26, given that 25(1) is subject to other provisions? I'll have a word to say on other provisions. Is Article 26 essentially an extension framework to give effect to 25? Justice Bagchi asked that. Can a member of the denomination who is not in agreement with the religious practice question the religious denomination's right under 26(b)? How does that come within the purview of judicial review? If the state has made temple entry laws for Hindus, for Hindu temples, can courts create comparable equality directions for non-Hindu religious institutions, or should they defer to the legislation? And lastly, whether 2(b), particularly the throwing open clause, that is the second part.
Query is not question from the court that you are required to respond to us. We will resolve these issues. These are all our
Some of these are our answers.
Don't pose them as questions. We don't want another debate here to be
Well, I'm answering them. Your lordship doesn't.
No,
only
please don't answer also. You just, we will see the note. Huh? Let's proceed further. These are all court queries.
Well, I'm only saying that my view on some of these queries, I'm trying to give.
Because we don't want any another debate to be reopened here. We must conclude this matter.
No, I'll finish within my time. Within my allotted time, I'll finish with this. I'm only trying to.
Just respond only to.
Yes, very well.
They have raised, not that we have.
Very well,
What
very well.
we have raised, what respondents.
We keep on asking so many questions, irrelevant, relevant.
When I say your lordship, I mean it's in the course of discussion. I'm not saying that they are raised in that sense. They're in the course of discussion.
Concentrate on them and
Very
then
well.
respond whatever.
Very well. I'll read my submission then. There's no problem. I'll read my submissions. Now, Wallace, I am submitting, Wallace, that there is a distinction between entering a temple and mirroring it. I'm sorry, and managing it. There is a distinction. That is the question raised. There is a distinction and entering a temple and managing it. That distinction is mirrored in the constitutional text. Page 7. 25(2)(b) concerns access to Hindu religious institutions of a public character by all classes and sections. It is directed to entry and worship and to the removal of caste-based and caste-based exclusion. 26(b), by contrast, safeguards the right of every religious denomination to manage its own affairs. This includes the authority of the denomination over ritual, discipline, observances. 25(2)(b) does not authorize, that's the proposition I'm canvassing, does not authorize the state to alter the denominational character or composition, nor does it authorize, in the guise of 25(2)(b), your lordships cannot allow that to happen. To read 25(2)(b) as overriding or subsuming 26 would negate the specific autonomy guarantee in 26 and contradict the framers' deliberate decision not to subject 26 to other provisions. Proportionality is important. Proportionality is not the, my answer is, proportionality is not the first stop test. It is a second ground when your lordship looks at the reasonable restriction. In a case involving a reasonable restriction, there your lordship will apply proportionality to see whether the restriction sought is proportional or not, but not a first test. Kindly see that. Proportionality may serve as a useful analytical tool to test the extent of restrictions imposed by law on religious freedom. However, proportionality cannot be used to create a new ground of restriction beyond those specified. It's in the restriction that your lordship looks at, that your lordship applies as a tool, proportionality, not as a separate test. Any interference with the freedom of religion must be by or under law and must fall within the constitutional enumerated grounds, which are public order, morality, and health. Then come to 2.3.4. Thus, proportionality may apply at the second stage. Once a valid constitutional ground and valid law are identified, the court may examine whether the restriction is excessive, disproportionate, or destructive of the protected right. That's the way your lordship will apply it in my humble submission. It cannot apply at the first stage so as to invent a new head of restriction, displace a denominational autonomy, or convert judicial preferences. Then, Mullahs, whether 25 limitations are rendered nugatory by 26. Now, Mullahs, kindly just see the 4.1, 2.4.1. 25(2)(b) cannot be interpreted as to decimate or extinguish the primary right under 25. To interpret it otherwise would mean that the main religious rights under 25(1) could be destroyed in the name of social reform without the discipline of the specific derogable standards. So that is clear, Mullahs, your lordship has standard.
I think 2.4, there is no serious issue. 2.5, there is no issue, serious issue, because case to case, you are right, we have to decide on case to case basis.
So let's just stop at 2.5.3, Mullahs. 2.5.3. Your lordships has to do case to case, but these are the general broader guidelines the lordship will look
That's
at.
it. These are the judicial guidelines in a way.
Such principles may be the distinction between religious and secular activity, not between essential and non-essential. Religious belief and practice from the point of view of the denomination or community. 25 and 26 harmonized without extinguishing. Interference must be by law within the textual heads. 25(2)(b) cannot be used to reform. These are generalities your lordships could put without case by case. And proportionality. Now, let's 26.
You can briefly point out if you want to say any on the interplay between 25 and 26.
Yes.
It has been argued in so detail.
So, no, but I want to say just two things. One is in 2.6.1. 26 cannot be elevated to a standard where lordship says it is superior to 25 in the abstract. It is superior in many ways, but to just say generally that it is superior to 25 will create problems. it is, Malas, not right to say that in every case 26 will override 25. Your first attempt is, Malas, clearly to bend over backwards for harmonization. If it comes to irreconcilable, then the denominational right will prevail. That's what I've said there, Malas. But sometimes, Malas, it suggests as if 26 is a superior provision and it will override 25.1. Now, let's just see para 2.6.3.
2.6.
6.3. 2.6.3.
2.6.4, you have given those.
Yes.
What the court should not
can
do, that is important.
Yes, Malas. Very well. Let me read 6.4 where I've given a whole list, Malas. On the, this is part of your Lordship's formulation. On the question of judicial review, derogation of fundamental rights under 25 and 26 can only be by way of legislation on the constitutional grounds mentioned. This must be so as any restriction imposed can be only on these grounds. The court should not undertake the following queries. So what your Lordship should not do? Whether religious practice is rational or irrational. These are no-go areas in my submission. Whether court considers the practice progressive or regressive. Whether the practice is essential or non-essential. Whether the practice accords with the subjective preference of dissenting members or non-adherents. And whether the court would have framed it differently had it been designing or looking into the faith afresh. Now, Devaru, I believe, as Mr. Vedantha also says, there are parts which are clearly wrong. There are sentences which Lordship will have to clarify. But in the result, it's got it right. That's the one sentence summary of Devaru. There is a part where 248 is clearly wrong reasoning, but the result is right. Now, let's kindly come to 3. Whether the rights of religious denomination under 26 are subject to other provisions apart from public order, health and morality. Just come to 3.2, Malas. Malas, may I pause here? It's not written here, so Lordship will note. Justice Nagarata asked a question today again. Let me give as straight an answer as possible, Malas. In my humble opinion, your Lordship may hold that subject to other provisions for the part of 25.1 alone, not other things, can be harmonized to mean that all parts of part 3, which are horizontal, where effected or invoked, may trump 25.1. But all parts of part 3, which are not horizontal, will not necessarily apply on that phrase subject to other provisions. That's my first point. It's very clear, Malas. So horizontal rights, yes. Number 2, what are horizontal rights? In my humble opinion, Malas, they are 15 to 17 and 23 and 24. I don't agree with respect, Malas, that 19 can be called a horizontal right. I don't agree with respect that 14 can be called a horizontal right. Now, if that be so, your Lordship treats on an equal plane where religion meets religion, your Lordship applies a horizontal test. Where religion is not involved, except in some right in 19 against the state. So that is the best way to harmonize in my humble submission. It minimizes problems. However, Mr. Vedantha put a useful, important caveat. There may be some rare cases where the speech is so brazen on issues of religion as to invoke the derogation under 19.2 head. There, even then the principle will remain the same. Not that 19 will apply as a horizontal right. Your Lordship may commonsensically apply that, look, this is bound to decency or bound to national integrity.
Morality is anywhere in 25.1 also.
That's right. That's right. Morality is also a test.
Decency and morality.
Correct. So I was trying to answer this, but therefore that is the harmonization I would plead for.
They could have said, the framers could have said, in view of the other provisions of part 3, the state is enabled to pass law on A and B under Article 25.2. That is meaning 25.1 is subject to other provisions of part 3. If they had brought that expression subject to the, in view of the other provisions of part 3,
they could have made it more clear.
the state is empowered to make laws on 25
Lordship is,
A and B. It in a way brings 25.1 also subject to the other provisions.
But since there is
placed it there, It's a
Religious interface- Since there is no religious interface and rights are horizontal, it's a fair division between vertical and horizontal. That's what I. Now, Lordship will skip 3.2 and come to Mills. Family-owned temples in 3.3.
Also, that has been stressed well.
Yes.
For morality part has been.
I only want to say, 3.3.2, there are two views a Lordship may take. One is a Lordship may clarify and overrule Mittal.
Almost try to hear constitutional morality, public morality.
No, that we are, well, I have opposed it in my written submission.
We want to now keep intact our convention.
Your Lordship has perhaps forgot, I have taken very strong exception to constitutional morality.
Will not become a case of overflowing.
No.
And then
I have made the submission, my original submission, that constitutional morality is a very unsafe yardstick to travel in choppy waters on uncharted seas without an anchor or a compass. It's completely, you Lordship may apply it sometimes for some ethics or some legacy, etc., but not in a general way as an additional ground to decide matters. And Justice Nariman in Sabrimala itself has said so.
So what my Lord the Chief Justice is trying to say is, it is a saturation sometimes that from April 7th onwards, even in the middle of our sleep, we are saying public order, morality, and subject to the other provisions. Yes, because we are thinking with you.
Yes.
We are reacting. So these words are, it is coming in the
Saturation only lasts
middle of the night
1.5
also.
My
And
lords
as soon as we
and
get
my
up-
lady,
Yes.
we will soon be reaching the 41-day Vratam period by these arguments from 7th April onwards. In terms of time we've taken, we will have completed the Vratam to go to Sabrimala.
Now, this family temples, I'm only making one point in 3.3.2. Your Lordship has two options, either overrule and clarify Mittal or keep it as it is. I have dealt with it both ways. Keep it as it is. Your Lordship still has a difference between private temples and public temples. And the differences I've given here, I'm not reading it. It can't be that you obliterate it. And it's also not that every temple of a private home, inside a home, is elevated to that status. Your Lordship there are errors in Mittal, but your Lordship need not overrule 10, 15 judgments. There are problems with sentences of every judgment. The Lordships can clarify some parts and just harmonize it. Otherwise, every judgment has a problem. Now, issue number 4.
Five.
Issue number 4, I'm skipping. But I already said so. I'm skipping it. Your Lordship has got this coming out of the years now, constitutional morality. So I'm not suggesting, but this is a
judicial review.
Strong reiteration of my submission originally also, that this is an infirm way of doing it. And Lordship will read that footnote of Justice Nariman, who is very clear in the Sabrimala case.
Yes.
Then verse 5.
Scope and extent of
Judicial review. Now come straight to verse 5.2. 5.2. Now this is balance between a judicial review with regard to religious practice under 25. Where there is a conflict between an individual believer's right of conscience under 25.1 and the denomination's right under 26b, the denomination's right must prevail in matters of religion. I've given the clear answer to the best of it. I'm not making bones about it. 25.1 is expressly subject. That means also subject to verse 26. This does not mean that a denominational practice is immune from all scrutiny. A challenge to a denominational practice may succeed if the practice violates these three millets, or if a valid law within 25.1 or 25.2 constitutionally restricts it. I have in my submission, perhaps a little different from those on our side, said that entry must still be governed by 26.2b, 25.2b, and not 26. After you enter, I'm not suggesting, as Mr. Dhawan said, that you enter and then you just drove around outside. All parts of your worship inside will be governed by the denominational requirement of 26. And there's a third level. The sanctum sanctorum may be regulated even more specially. So you have to abide by that.
No, what is the meaning of entry? And if you are asked to stand in a corner, yes.
No, so I'm saying.
The sanctum sanctorum.
No, I'm saying entry everywhere. I'm saying the opposite. I'm saying that your Lordship once entered.
Sanctum sanctorum is all right. But once you enter,
everywhere.
have equal access.
Absolutely. That's my submission.
Yes.
Except that once you enter and you're going everywhere, you have to follow the denominations, broad contours. There are places where you wear a dhoti, where you have to do this, That's what I'm saying. But even after having entered, you are not allowed to enter the sanctum sanctorum is another category.
Yes.
So I'm not suggesting that once you enter, you stand in a corner. That's the clarification I'm giving. Not at all. Entry means meaningful entry, real entry, substantive entry, worship entry, not just to stare at the wall or something. But there are restrictions of all kinds in terms of how you may do, what time of the day, how you will go into. All those are part of the rules. Everybody has to follow that. If you don't follow, sometimes you can't go in some places, jeans or half pants, etc. You can't do.
Even to a court, you can't do that.
Can't do it. Then,
Discipline.
discipline. The judicial review in 5.2.3 is limited to whether, as a matter of fact, there exists a cognizable religious denomination satisfying the constitutional
You are
criteria.
classified in 4 subcategories.
I beg your pardon?
The scope of judicial review.
Yes, 5.
Yes, maybe.
Yeah,
four.
overlapping, but yes, broadly 4 or
That's
5.
right.
4 or 5.
But I think that note
right.
answers everything.
Yes. Then, second sentence of 5.3.1 is what I've just said, that internal religious management, 26B will trump most other things.
We can come to state 7.
Yes, 7 I'm coming to just in a minute. Just in a minute. Let's just see 5.4. There is sometimes an inroad by calling it superstitious practices, irrational practices. Practices observed by religion which are not regulated by state-made law may be amenable to judicial.
Dr. Singhvi, ultimately judicial review is a very flexible principle.
Yes, very well.
The moment but a set of facts, set of legal principles come for consideration, the court will start expanding or restricting accordingly.
And ultimately it depends on the dexterous handling by the judicial hands, which understands the difference between this and that. My summary of that judicial review on this point, on superstition.
The hardliner will say you don't have power of even a postman, so you can't entertain letter.
That is not the way it
The
works.
others will say you are a post office, you must open every letter, read it, read the contents, interpret and reply the
judicial
sender.
rights in between.
So this all depends upon how.
Whereas 5.4.2 gives the contours in the argument of superstitious, only that. Your lordship will not normally enter into regressive, irrational, superstitious, unfamiliar. These are external standards. Your lordship will not allow this to enter. That's my summary in 5.4.2. Now let's ignore this 6, there is nothing. Come to 7. On 7 again, maybe I'm wrong. I believe there is a large consensus on most issues, even from their side and mostly on our side. Some people on their side. And may I just, there is of course dissent also. Let me make these submissions very quickly. 7.2. PIL by a non-believer. 7.2. Ignore the first, come to 7.2.2. If your lordship recollects my submissions, I gave your lordship the appendix chart of 23 cases in the opening. All were suits or primary proceedings. There was one writ in a different context. I've given you also a listing. It is not also that your lordship as a matter of course have been entertaining PILs. It's because Sabrimala, etc. achieved a certain largeness of size that it appears that your lordship is entertaining. Why are all these? Your lordship has heard so many cases, Devaru and Shirur Mat and all. Why have they arisen from suits and primary proceedings? Even after that, in the later cases also, it's not that it's just some PIL can come in. So that para 7.2.2 is mentioning my appendix in the original written submissions. Then 7.2.3, believers and the denominations are placed in the position of respondents. This is a very important point, and are required to defend the religious practice at the instance of people who are not members. What is public law, morality, etc.? Public order, morality, etc. These are challenges which I will make against some legal inroad into my right. I'll be the petitioner. There is no law and inroad by the government or anybody in my right. I suddenly appear as a respondent in a PIL file where I don't know how I defend also my religion, and there is no real valid place format to apply the test of derogation. How does these 3 derogations arise when I am the petitioner? Then come to 7.2.4. So the matrix, the equation is wrongly framed. It's wrongly framed. A non-believer or non-adherent ordinarily lacks sufficient interest in challenging the internal religious practice of denomination. Religion is a matter of faith. A non-adherent cannot claim personal injury merely because another community follows a practice which the non-adherent considers objectionable. To permit such PILs would allow one section of society to invoke constitutional adjudication to unsettle the faith practices of another without demonstrating direct injury, statutory violation, or state failure. And then I end, Malas. I will not read it.
7.2.5, I think that probably.
PIL jurisdiction is intended to vindicate public injury, particularly where people directly affected are unable to approach. It is not a jurisdiction to enable strangers to religious faiths to invite abstract adjudication on the validity of religious practices, where the adherent community does not seek relief and where there is no direct state action. The second is also important, Malas. Where there is no direct state action, the court ought not to entertain. Your Lordship neither has either, and then suddenly I am a respondent.
So this entire 7 is summed up here. So
Yes. And then, Malas, overall rejoinder is just a summary from each of the sections. Now, Malas, I'll take 3 minutes before I end on something else, Malas. It is not necessary, but it has become necessary for 3 minutes because of Malas' somewhat gratuitous jump into a issue not arising today by Mr. Siddharth Luthra. This matter, I am having 2 briefs, Malas. One is Sabrimala. I'm not talking of Sabrimala now. I'm done. I finished. My learned friend, Mr. Luthra, Malas, in the course of arguments, started talking of cuffs, the practice of female circumcision amongst the Bori community, which is one of the matters. My points in 3 minutes are these. One, to strongly rebut not only him, but to caution your lordships. Sabrimala is a matter decided factually and is in review. In fact, it has a second review order. The matters tagged with it have no factual basis. Suddenly somebody says, well, if I am arguing something else, I say this to your lordship. Your lordship observes something in the order. It will finish off those cases. There is also Santhara in the Jains. There is also this Boras. Those are issues that have no factual basis. And just because somebody will prejudice your lordship should be very careful of observing. We heard it, so we were concerned. Secondly, Malas, I pointed out in a note I have, which I may hand over, Malas, I have a 2-page note. Not only was there no factual substratum, but your lordship should know that this is deliberately and consciously always called FGM, which is an African practice in African tribals of calling female genital mutilation. This is Malas done by one of the most prosperous and progressive communities based on 500 years of texts, 1400 years of texts, in a ceremony which is just Malas touching the nicking the Malas precipice of that organ in a formal ritualistic ceremony. In fact, very similar to Malas, the mandatory nature of male circumcision amongst the Muslims. Now, suddenly it is start calling female genital mutilation, which is an African tribal distortion. And your lordships hearing something else are asked as if, well, the lordship will make some observation. That's why I'm only cautioning. I don't want to argue it. I don't want anybody to get into it. And well, lastly, it is told to your lordships that if I oppose, well, as the female child 7-year circumcision at age 7, then I'm excommunicated. Well, I'm representing the community. It's a complete falsehood. The association which I am representing has 80,000 women, Malas. It's the most highly educated community in India, Malas. Bori, Daudi, Boris. No excommunication. It's a purely voluntary, ritualistic, kind of an auspicious thing, Malas, which happens on a certain date. And several parents may not do it. But your lordship is to be prejudiced to say, if I don't do it, I'm excommunicated. It's mainly the mother and daughter who do it. In any case, I am not inviting anything. I'm only asking your lordships to beware. There are a lot of other matters here. Your lordship, if at all, will look at facts to understand the issue in the context of Sabrimala. My lord will not start looking at facts which have had no primary determination of facts. I have not argued it. I'm only responding. I'll give a 2-page note, but just in case. Yes. And well, of course, in my note, it is stated that 1400 or 1300 years of texts. It's part of the Harat. I'm very deeply obliged.
Just to complete
I kept within the time.
Just to complete, because it was on the community, just 10 minutes on it and I'm done.
5 minutes, 5 minutes.
Very well done. Right. Whatever your lordship says, just quickly. I consciously in my opening did not touch any of the facts of excommunication because the facts were not before your lordships and your lordships are purely deciding questions of law. 3 hours were devoted to facts of the denomination and what was happening. just to very clearly bring out to your lordships notice what is happening and what is not. One, my lords, the judgment itself categorically says that as far as excommunication is concerned, for religious practices, it cannot be termed as a social reform, but it was for social reasons or an abhorrent social evil, the court could have considered otherwise. My Lord, the Chief Justice also put a question that could the 5 judges bench not have read it down? Your Lordships put a question to me. I went back to the judgment, my Lord. It was a very pertinent question. The judgment deals with it and says because it's a consequence base, the definition of excommunication is not given. It's the consequence which are given therein. It says that to read it down would amount to rewriting the section and judicial embarking on a judicial legislation. But they clearly make the distinction that only for religious practice, not for other purposes. One. Secondly, my lords, your lordship said that why were other people not parties? Now, my lords, I represent the head of the community who challenges a legislation. Now, in that, the state is represented by the Attorney General of India and the Advocate General. Now, as a Solicitor General. Now, my lords, with 1.5 million people as part of the community, who am I supposed to make a party and not a party in a challenge to a legislation? Secondly. Thirdly, my lords, most importantly for your lordships to know is that the institution of the...
In such like situation, you are absolutely right. You can't impede the people. Maybe many of them most of them are unknown to you. But there is a duty cast on the court to issue a public notice, to invite the person, those who feel themselves to be stakeholders. Why the court should serve from that responsibility.
But my lords, that in itself doesn't make a judgment bad.
No, bad or good, we are not right now.
All that I'm saying is, today I'm saying is, my lords, today what has been done are instances given to your lordships from a few thousand people reporting. We have put many more affidavits disputing each factual ground. Factually, society, book being written, speech being given, and not grounds for excommunication. Now, that's one thing your lordships must keep in mind. It's important for us that the institution of the Dai, who's really the vice regent of the Imams who are the progenies of the Prophet Muhammad, and the Imams are in seclusion. So the vice regent, that is the Dai, represents the Imams. My lords, the deepest core creed and tenets of the faith require total allegiance to the Dai, because through that is the allegiance to the Imam and the authority of the Dai. What is being questioned or was questioned therein, my lords, was this very authority to maintain the purity, keep the flock together, maintain a certain discipline, because what is it meant for? An impression was given to your lordships as if for every trivial issue, there is an excommunication which takes place. Let me tell your lordships, in the last 60 years, there has not been a single case of excommunication. It is restricted to religious practices where someone challenges the deep creed, tenets, and the very existence of the faith. That's what it's kept for. And my lords, really, as far as excommunication is concerned, it's not peculiar to our community. Many communities over the years, and it's discussed in the judgment, has been done to keep the flock together. It's essential. It's considered essential. And the judgment, that is the Constitution bench judgment, makes the distinction and recognizes why it's essential to keep the faith together. If you are violating the most core tenets of a faith, can a person who's the head of the community not have the right to excommunicate you? And the judgment says that merely because some civil rights are affected cannot be a ground to say that this is a social reform we are bringing about. Till it is not a religious practice, till it is a religious practice, it cannot, under the garb of social reform, reform a religion out of existence completely. So, my lords, we are dealing with a case where there's a history of the Dai with an authority given. And as far as the Misak is concerned, my lords, I may also tell your lordships, what was done? My lords, to your lordships, certain paragraphs were read of the Misak. That's all that was done. Firstly, my lords, keep in mind that initiation in any religion, whether it's the Jews, Christianity, Islam, there is a process of baptism, there is a process of initiation. The danger lies, my lords, when we pick up a document which has a history of 1,500 years and then start interpreting it literally. My lords, with any of our scriptures, what have your lordships seen? They're esoteric in nature. Interpretations are given which have a philosophical context to it. There's a text, there's a context, there's a philosophy behind it. And it is in that context it's seen. It's picked up and argued to prejudice.
broadly, there can't be any dispute on this principle.
Yes.
The only problem is that if the court becomes a super spiritual leader or a super religious leader and starts interpreting, then you may be right. But where the parliament or legislature step in as representatives of the will and wish of the people,
Right.
then the court's first presumption must be that it is the people who have demanded this reform. It is the masses who are demanding this reform, and therefore legislature has stepped in.
Right.
That presumption, unfortunately,
And-
sometimes is swayed away.
And at the same time, my lords are absolutely right, what is fallen from my lord the chiefs. But at the same time, my lords, your lordships always see whether that falls within the realm of social reform under 25(2)(b) or not. Or is it purely a religious practice? Because if it's a religious practice, then in terms of what is contained in Article 26, which is health, morality, and public order, is all that the state can legislate and restrict it on. The moment for social practices, you start restricting a religion, and that is why I had pointed out to your lordships in Devaru, a conscious distinction was made then when it comes to untouchability, Article 17, opening a place of worship to all sections, for that 25(2)(b. For all other purposes, Devaru also says, as far as 26(b) is concerned, it must have primacy. That's what Devaru says. But it can't be that under the garb, and that's what the 5 judges deal with. Under the garb of social reform, you are bringing in social practices, which are not religious practices. These were clearly religious practices, my lords. The thy stature, his authority to excommunicate, are essential religious practices. In fact, the community believes, my lords, that if this authority is questioned, the very existence of the Bohra community goes. And if every other religion has the power to excommunicate, why should it not be there in this? If a civil right is effect, can be no ground for a social reform. It has to be something to do with a religious practice under the head of public health, morality, and order. That's the only 3 grounds.
Excommunication is not secular act.
The judgment says so. The judgment categorically, para after para, makes a distinction to say
Not a secular
that
act.
it is purely on a religious practice. If it were based on a secular or a social rule or evil, it would have been a different situation. The judgment categorically says so. A distinction traces the history of excommunication in Judaism, in Islam, in Christianity.
We understand.
And
We are not
that's it.
concerned.
So, my lords,
Sorry, dealing
today,
with
the distinction is made, and what is protected is excommunication purely on religious lines and nothing else, my lords. And that, my respectful submission is, my lords, beyond that, the facts is not what your lordships are getting into in this matter, and we've addressed on the points of all.
Article 32 also remains. The question of maintainability under Article 32 remains.
My lords, that your lordships told me not to address on, so I did not.
We are
No, no, no.
not considering it now.
Yes, but my lords, we will raise that objection at the appropriate stage whenever it comes.
Yes.
And my lords, lastly, may I only say, and I'll end with that, the judgment was of 62. In 77, a self-appointed commission is appointed, not by the government, which gives a report in 78. 9 years later, a writ petition is filed, which is the current writ petition. After the writ petition is filed, 6 years later, another self-appointed commission gives a report. So millions of Bohras who are there, who form the community, no one is consulted, and responses are got from 1,000-odd people. And on the basis of that, 2 commissions give their report. And we file detailed affidavits and responses to each instance, saying that they have disputed and strongly refuted their arguments of prejudice without any factual or legal basis. I'm very grateful, my lords, for your lordships.
Thank you.
That's good. She came and she. That's all. That's all. Very grateful, my lords, for a very patient hearing.
Mr. Gopal, approximate how much time you need?
I won't take more than 20-25 minutes.
25. Mr. Dhawan, how much time approximate?
three brief points that I wanted to make. The first, my lords, is with reference to, and I think I have to be fair to both sides on this, that as has been observed earlier, that this is not really adversarial beyond a point when we come to nine judges and looking for interpretations. One of those aspects of interpretation which I had the advantage of reading Mr. Subramaniam's submissions, and I found it there, is the High Court judgment in Venkatramana Devaru. I don't know if your lordships have had the chance to go through that. That is in volume 6.4. It's at page 1608. That's the judgment which has been sustained by the Supreme Court, but on entirely different reasoning. Now, the reasoning there, it may do violence to my case in Sabrimala, but I think it's fair for me to put it across because there is some reasoning there. The reasoning there says that the threshold issue with entry is to see whether it falls, and it can possibly fall in Article 26 at all. If entry into a religious place of worship doesn't fall in 26, then that question of a conflict between 25 and 26 won't arise at all in entry cases. It is fully covered by 25, 26 doesn't come into play. That's point number one. Your Lordship may just see it's paras 10 and 11, two paragraphs that have dealt with it. In fact, Mr. Nambiar and Mr. Venugopal appeared for the petitioners in that case. The second is that if your Lordship sees the Supreme Court judgment in Venkatramana Devaru, the reasoning that it starts with is perhaps where the error creeps in, because the very first sentence of that, which is at page 248 of the relevant volume, says, the result then is that there are two provisions, they're referring to 25 and 26, two provisions of equal authority, neither of them being subject to the other. And that's where the reasoning starts. Now, clearly, once the words subject to the other parts of part 3 are there, for this premise to be the starting point is the error. The High Court doesn't have that error. The Supreme Court has that error. So I think that error would lead to that reasoning, which does violence to the Shirur Mat reasoning, which we adopt respectfully. But I think there is error there in Venkatramana Devaru that your lordships may consider, either going the High Court way or going the Shirur Mat way, but not adopting the Supreme Court's own approach. One point with Mr. Mohan Gopal had made on autotheism, I don't want your lordships to be misled that there is a meaning given to autotheism. He was suggesting that that is what we follow actually here. It isn't. Autotheism is a specific word which means that I treat myself as God and therefore I follow myself and my beliefs. That is not what we follow in Hinduism remotely. So please don't employ the word autotheism. I think that needs to be rejected straight out. Finally, my lords, on this horizontal and vertical, I think one more question arises from that. We have so far, and I adopt everything that Dr. Singhvi had said before, apart from looking at 15, 2, 17, 23, 24, and of course this issue that we have on 19, I think both of us are on the same page that it's not horizontal as for 19. A central question that may arise is Article 25 a horizontal right? Because, and a lot will flow from that. If Article 25 is a horizontal right against 26, which means the individual says, I have a right against the denomination, not against the state. 25.2 makes it clear that state also is playing a role there. But is 25 also a horizontal right against the denomination? The consequences then, how do you disentangle that? My view is it says subject to other parts of this, therefore it's subject to 26, therefore it's subject to the denominational right. It's easier perhaps that it's not a horizontal right at all. It is only a vertical right. It's a right of the individual against the state interfering with his or her rights in the faith. In which case, the 25 individual can file an Article 32 petition separately under 26 and State Trading Corporation, which is a 9-judge bench, which goes into citizen and person and says whether a corporation can be a citizen or a person, doesn't touch this point. It in fact looks at part 3 only as citizens and persons, forgets the fact that 26 uses the word religious denomination. I think a religious denomination does definitely have that right. So it's a third category in which Article 32 petition.
Isn't a person under can challenge Article 26, right?
In my view, an individual can't challenge the denomination's right under 26. It cannot. An individual cannot do that. Therefore, 25 is not a horizontal right against the denominational 26 right.
He cannot challenge.
He cannot challenge. That's my view. I believe that therefore a fund. Yes.
You cannot challenge in any forum.
No. As a fundamental right. Only as a fundamental right. I'm saying the right which you have in a suit, etc., obviously you have.
Before you can say it's a civil right, cannot be tied, it can be traced under 25 only.
I'm saying it's not a horizontal right, Manoj. Simple. That's the simple answer is it's not a horizontal fundamental right.
That's correct.
Yes, in the constitutional context. That's all I'm saying. In the constitutional context, that challenge cannot be brought. I just wanted to adopt what Mr. Vaidyanathan said, a deep gratitude for the kind of patience you had and the kind of learning, my deep gratitude to everybody at the bar, especially the non-seniors, because I've learned so much new material from them, particularly my colleague Shraddha Deshmukh. I thought her presentation yesterday was outstanding. I'm grateful.
Thank you, Mr. Gopal.
I'll take
Yes,
2
Mr.
minutes.
Guru.
1 minute for saying I'm not going to rejoin my lords in the review petition.
2 minutes.
Now, my lords, I'm just giving one note, supplementary note for an intervener. This is with regard to, my lords, on the essentiality. Ram Janam Bhoomi, when it says, Ismail Farooqi says, acquisition of places of religious worship cannot take place, but in case there is some place of worship which is so integral to the religion, that only if that acquisition is so central, the religion itself will go away. Then such acquisition cannot take place. That formulation, my lords, of the principle is something which cannot pass muster under 25 or any constitutional principle, my lords. This is really what we are trying to say. And I've given, my lords, several instances of places of worship, my lords, which by themselves are very important as a matter of religious significance. Just have a look at, my lords, para 3. Para 3. Para 3. Several other examples where we have enumerated, my lords, all of these places, where, my lords, the places themselves are of such immense importance, it cannot be that the law is that minus this place, the religion itself will go out of existence. That's the formulation, my lords, which has been made in...
The essentiality test goes, this also will go.
Exactly. Therefore, I've given it para 4, Ismail Farooqi, my lords.
Sorry, Lord, for the interruption, my lord, in Ismail Farooqi, it was decided on a different point.
I know,
That
but then
it is because of a particular significance of a particular place that it was a temporary acquisition act which was under challenge.
Exactly.
We did not go into all this
No, but
for the purpose of answering this question.
no, therefore I'm only saying as a formulation it is there. That needs to be, my lords, addressed because my lords are in 9 judges. Para 4 and para 5, my lords.
For answering these questions,
Yeah,
for
that's
the
correct.
temporary acquisition,
Well,
which the judgment is delivered,
Whatever
which is now
the
delivered.
learned solicitor may say, my lords, on the relevance of this, I am saying while answering 25 and 26, my lords, this becomes important. Therefore, as a formulation,
You
I'm
understand?
respectfully
You
submitting.
understood.
I'm submitting, my lords. This needs to be looked at, my lords, by the 9 judges bench. I'm deeply
Yes, Mr.
obliged.
Sain.
I'll just take exactly 5 minutes, not more than that.
May I just add to the solicitor, the acquisition was struck down. Therefore, all this is obvious.
Because while it's being handed over, I won't waste time. Can I just proceed with this? In volume 1.2, at page 255, under the heading, Part 3 Limitations to Article 25, specifically the question that my lady put has been answered. And the broad position I've taken is this. Given the horizontal nature of all those rights, it is not possible for those rights and under Part 3 to act as limitation with respect to 25(1). That's the specific statement I've made. And I've also said, please, please.
Volume 1.2.
I'll just, volume 1.2, page number 255, Roman 9 to Roman 12. I'll just take 2 minutes. Let me just read it because it answers the question straight off. Coming to the other provisions of Part 3, which limit the enjoyment of Article 25(1), Kaushal Kishore treats Article 14, 15(1), 16(1), and 16(2) as vertical rights, which are available to the state. Consequently, it cannot be contended that they're available to individuals in horizontal application qua religious institutions. This was a conscious decision taken by the framers with the knowledge that secular equality does not apply to religious institutions, given that they subscribe to scriptural mandates or tradition. In fact, even 15(2), which has a horizontal character, does not apply to religious places. It is conspicuous by its absence. Similarly, 16(5) shields any law from the mandate of Section 16 if it relates to an appointment of any person to any office in connection with affairs of any religious or denominational institution. Therefore, the running train of thought is clear.
Why is an exception?
It's an exception, but even there, so it's an exception to 16.
So the argument of the other side was
Please.
that all these subject to the other provisions of Part 3 means
Please.
this 25(1) has to yield to that.
It does not. It
How
cannot.
can that be?
It cannot. Then it defeats the core of 25 and along with even 26 is washed. So therefore,
There is as good as no 25 on right then.
I'm grateful. So this is, I'll just repeat the page numbers, pages 255 and 256 at volume 1.2, Romans 9 to 12. I won't repeat that here. Could my lords kindly have the rejoinder note for a moment? Here's something I've done for my lords.
You can just highlight this.
I'll highlight this. So under point number A, I've dealt with the discussion of the relationship between Articles 25 and 26. The one thing that is fortunately emerged as a common ground everywhere, at least across the board here, is that religious denomination is not some exalted denomination. It is an association of people, and therefore no higher order tests need to be applied. To that extent, I think there's a commonality here. There's just one more submission. If my lords could kindly come to para number 3, what I've done here is this. I've already made the submission in the first round that 26 is similar to 19(1)(c) in terms of religious context. Therefore, 19(1)(c) is governed only by 19(4). There are extra limitations on 19(1)(a) and 19(1)(b) under 19(2) and 19(3), but they cannot apply to 19(c) because 19(4) is self-contained code as far as 19(1)(c) is concerned. Similarly, therefore, limitations that apply to 25(1) cannot be imported into 26. Because whatever limitation is supposed to apply to 26 has been specifically spelled out in 26.
That phrase is not there in 26.
I'm so grateful. That's one. So what I've done for my lords is this. In the last portion of the rejoinder submissions at page number 7, under subnote C, what I've done is that I've extracted the entire debate with respect to 26, which explained why part 3 was not made applicable to 26. That's point number 2. Final point is for my lords to consider. On 25(1) and 2 and 25(2)(b) and 26, I've taken the position that the same religious denomination has rights under 25(1) because 25(1) speaks of persons, and therefore it includes body corporates and association of persons. And it also has rights under 26. I have attempted to show here that the rights under 26A, B, C, and D are not impacted by 25(2)(a) and 25(2)(b) at all. They are not impacted whatsoever. Because, I'll just explain this, my lady had actually pointed this out. Practice of religion is a specific term used in 25(1). Secular activities associated with religious practice is the term used in 25(2)(a). Matters of religion is the term used in 26(b). All of these are very different because matters of religion are governed by 26(b). Secular activities associated with religious practice is governed by 25(2)(a), which means 25(2)(a) strikes a compartment between secular aspects and religious aspects. The moment it enters the realm of religion, 26(b) governs. Therefore, what I'm trying to say, therefore, is, and I completely support Mr. CSV's statement here, the conclusion of Devaru is correct. The reasoning is problematic, is the only submission. And let's just one more submission to leave it at that. Devaru does not address the question of what happens to private denominational temples. Because it was a finding, concurrent finding, that it was a public character institution. 26 applies to denominational institutions. Therefore, two categories, private and public. Devaru never addressed this question. 25(2)(b) is clear in its own language that its application is limited only to institutions of public character. Therefore, as far as private denominational institutions are concerned, 25(2)(b) will not apply. On this, just one final submission, I'll leave it at this. Please note, the nature of 19(1)(c) in terms of association is exclusivity of membership. So a denomination fundamentally carries with it a presumption of exclusivity, unless it is of public character. And private denominational institutions are not limited only to family institutions because this court has recognized non-familial private institutions as well. Therefore, I'm limiting my submission to say Devaru is silent when it comes to private denominational institutions. As far as private denominational institutions are concerned, they can't be affected by 25(2)(b). The state has the power under morality, public order, and health to anyway interfere with it. So it's not as
Denominational institutions?
I'm saying then 100% because Hindu denominational institutions of public character, Hindu religious institutions of public character includes denominational as well as non-denominational. So to that extent, a denominational institution that otherwise has rights under 26 but is open to public will anyway be subject to 25(2)(b). There is no need for any other interpretation.
I don't think there'll be difficulty on this. You are right, Luis. Yeah. I don't think there's any adjustment.
Just one final submission, please. I'm so sorry. 30 seconds, not more than that. Yesterday, Article 290A was pointed out. And there is a judgment of this honorable court in the context of the Padmanabha Swami temple case, delivered by Justice Indu Malhotra and UU Lalit. And the point was this. 290A was a consequence of a Travancore proclamation by the Maharaja taking over all those temples. And when he negotiated the settlement with the Indian Union, he said, my obligation to pay lands, the annuities to those temples, the union will take over. This is specifically captured as part of the covenant of merger. And therefore, It is not an aberration. It is one of the conditions of accession and merger that has been incorporated by Article 298. Grateful. So deeply obliged.
Wait, please, Manoj. Manoj, I am addressing only 3 points quickly, Manoj. Judicial review, Manoj, on this point. Any state action which violates Article 25(1) right or 26(b) rights will be tested under Article 32 and Article 226. Your Lordship have a jurisdiction.
Yes, I'm just handing over my notes. I'm sorry. Great.
On case-to-case basis, your Lordship will adjudicate on the limitations which is available in the Article 14, including Article 14. Why I say, my lord? Say, for example, in the same place, two denominational temple, under Article 25(2)b, state make a law opening one denominational temple to all, but other group is not permitted to the another temple. So this is the conflict when it arises. Only we have to go under Article 14. So any test will be asked. Normally, your lordship tested any statutes under Constitution, Article 14, Article 21, any other provision by testing discriminatory, manifest arbitrariness, proportionality. This test will be squarely applicable to all enactments, all state action. This is the one. There will be a situation where inaction of the state. If the state fails to do public order, public health, public morality, that time also there is a possibility of filing a writ petition before your lordships, and your lordship will have a jurisdiction to decide. So your lordship's hands-off attitude may not be correct. Your lordship will have a jurisdiction under Article 226, 32 against the state action as well as inaction. Intra-section dispute or intersection dispute has to go to civil suit. That should not come into the 226 jurisdiction and side away taking the route and knocking out without evidence adduced. So there is a component of this adjudication by a judicial review on two places. That's on judicial review. Coming back, my lord, conflict between 25 and 26. There was an argument saying that 26 may not be necessary. It is only manifest of 25(1). First look, it may be correct because 19C is available. Association, forming association is now available. So 125(1) is that person can form an association. 19C rights, 1C rights can be taken. Why is it 26? That's not the way how you lordship looking into the constitutional provisions. One article cannot be treated as a surplusage. So it has a separate power. So that is the one point. Then, when coming to denomination, I just saw the argument of parsi religion. Parsi religion as a religion wholesale as treated as a denomination. There's no subdivision in that. So when it comes to a parsi, a religion whole as treated as a denomination, then why can't you do Hindu religion? That's one. Second, the section thereof will be ideal to interpret in this situation because how to interpret denomination. So if section is treated any group, any sect, or even a given case in a single temple can be a section. That is where we lost in Sabarimala. That's the third point, my lords. So the case-to-case basis, it has to be decided. Your lords may have a jurisdiction to adjudicate all these things. There's no hands-off attitude. I'm grateful.
Mr. Pasha. Don't open the laptop, state.
Madam, I'll also be handing over something with, but just in 2 minutes. Lordship, a very colorful argument was made yesterday by Mr. Hegde that I can wake up in the morning a Christian, be a Hindu in the afternoon and go to bed a Muslim. Lordship, I just, while Article 25(1) actually is broad enough to enable us to self-identify as what we want, when we want.
A couple of years back, we heard like this in politics, but not in religion.
If you really do that, at night you have to go to a psychiatrist. Then you need medical treatment. But if you do it in the morning, afternoon, and in evening.
Lordship, so while Article 25(1) actually is broad enough to give us the right to identify as what we want, human, animal, or fruit, but Lordship, there is also a corresponding the corollary that arises because the law also recognizes you. There are some implications that follow. For instance, Lordship, if I wake up one morning and decide that I feel sick today, I can't demand that I be allowed to contest elections to the SGPC. So for instance, the Travancore boards, there's a requirement that the members must be Hindu. It can't be that somebody who has decided that this afternoon I am a Hindu, I become entitled to be appointed. Lordship, similarly, the denominational right or the right of the group, there is no corresponding obligation on the group to recognize these self-identifications which are swaying with the winds. And that, Lordship, becomes important because for instance, the example which is being taken of the Dawoodi Bohras. While someone may believe anything, may believe anything good, bad, ugly about the Dai, may identify with him, not identify with him, not think of him as right or wrong, may therefore still think that he or she is a Dawoodi Bohra. But there is no corresponding obligation in the community to recognize that person as a Dawoodi Bohra. And that is why, Lordship, my argument was that consciously the Constitution has placed the denominational or the group right higher than the individual right, because the individual exercises 3 levels of choice in before they come to an institutionalized religion. And therefore, the right of the institutionalized religion is greater in that they may have rites of passage. They may have certain markers. For instance, for Sikhs, I might give the example. Lordship, there's a Rehat Maryada. Lordship knows that the 5Ks, etc. You have to have Amrit in the Gurdwara before they can recognize you as somebody who's entitled to contest, say, elections to the SGPC, which is one of the ways of management of properties and institutions for the community. Lordship, therefore, since consequences follow, and that my first argument is there is no corresponding right on the collective to recognize these very highly individualistic and eccentric self-identifications. Second, Lordship, on Mr. Darius Khambata's argument, Lordship, an argument was actually, a proposal was actually moved in the Constituent Assembly by Minu Masani, that there should be an obligation created that nobody can create a hindrance of any kind to an intercaste or interfaith marriage. And Lordship, there the philosophy of that Dr. Ambedkar has also written about. He said that the end to the conflicts of India is intermarriage, so that all identities are merged. But Lordship, that was defeated, and we have chosen a model where we have given the right of preservation of identity to individuals and particularly to communities. Lordship, and while every day Lordship accords protection to young couples who have married interfaith, intercaste, interreligion, etc., Lordship, that is the choice of the individual to choose their partner, and that choice will always be protected if any third party seeks to hinder that choice. That doesn't disentitle the collective to create incentives and disincentives for its own stock to, for instance, marry within the community. And Lordship, I call that the liberal hypocrisy, that the argument that Mr. Farasar took, that while, for instance, Navtej Johar, the right of a man to choose another man as their partner is the shining beacon of constitutional rights. On the other hand, a Hindu or a Sikh or a Christian or a Muslim wanting to choose a partner from the same cloth is looked upon as an example of constitutional immorality, because that's the context in which it was cited. So therefore, the collective does also have a right to preserve, to self-preserve and preserve their own identity. While children may choose to marry outside of the community, but the parents may still disentitle you out and throw you out of their will. Lordship, therefore, that same parental outlook also transfers to the community where, for instance, with the Parsi community. Lordship, I was just checking the data as per the 2011 census. The Parsi community is merely 51,000 strong today. Lordship, it's a community which is diminishing, and most of them are elderly. It's a community which tomorrow may lose its identity, because that's the trajectory which is following. Therefore, if a Parsi panchayat wishes to disincentivize interreligion marriages, and Lordship, eventually there are property rights in these. These are rights of the communities, right? They may choose not to allow you access in case, and that as a disincentive. Lordship, and therefore, when the hierarchy is prescribed between the collective and the individual right in 26 and 25, Lordship, the double proportionality principle from the electoral bonds case was cited by Mr. Khambata. Lordship, I just wish to point out that even in the double proportionality principle, the first test is, does the Constitution create a hierarchy between these rights? If yes, then which right has been granted a higher status will prevail over the other right involved. Therefore, Lordship, even in the double proportionality test, when balancing is done, it is a relevant concern. In fact, the first concern, whether the Constitution prescribes a balance, a hierarchy between these rights.
Mr. Pasha, you have to take a stand.
Lordship, please.
Whether your stand is that excommunication per se, whatever be the reason, can be protected, or excommunication with regard to consequences. For anything excommunication, are you?
No, Lordship, in fact, the argument that was being made was that it is not even as if there is excommunication for everything. That's not even the position. That's not even the position within the religion.
But the example of the specific case of the other side was that for marrying out, there is an excommunication. Your marriage stands dissolved. If that is the fact, then probably the court will have to take a call on that.
And Lordship, in fact, that was the reason why the argument that very rightly Dr. Singhvi made was that a proposition on fact, which is factually incorrect, because there is no instance that they are pointing to that, here's the excommunication. These are all statements being made in the air, which in those matters are being contested.
The petitioner herself was a victim of that. There was a specific case.
Lordship, and that's a categorical statement of the community that in the last 60 years, there's been no instance of excommunication. And Lordship, I was actually very shocked when I was reading the... Lordship, just two more points. Lordship, as I was reading the 1986 writ petition, which is in question on maintainability, Lordship, the petition says that there's been no formal excommunication. They just say that it's all word of mouth, nobody talks to us. That can't be the subject matter of judicial proceedings. You feel you are excommunicated. It's not even as if you can point out to an order that there's excommunication. You are saying that your community members no longer talk to you, therefore it must be word of mouth, secret excommunication. That's the nature of facts that are pleaded, which Lordship can't withstand judicial scrutiny as and when they're taken up. Lordship, then on management, the point that I had made, that the right in 26 is of management, and that's a very different right. Lordship, I've handed over a note of international covenants on what kind of instances of rights are contemplated internationally within management. And Lordship, I've did that list that Lordship may look at that list in terms of appointment of leaders, teachers, publication for dissemination of information, etc. Lordship, what I wish to point out is that when one looks at these rights of management, society has a lower stake in these rights. That is why they're not subject to social reform, because if it is only about what is happening behind closed doors in terms of appointment of leaders, religious education, hours that the place of worship will maintain, etc. Lordship, the very nature of these rights, this is why, and Lordship will also see that these rights, for instance, they involve acquisition of properties, maintenance of seminaries, maintenance of institutions. Lordship, if 25(2) is applied to them, 25(2)(a) first, Lordship, the so economic, financial, political, that overlap is much larger with management. It will become a case of the constitution giveth and the constitution taketh away. If you make the right of management subject to a carve out of anything which is economic or financial or political or social, because then really nothing survives from management. That's very well for Article 25(1) rights, that it's not essentially a religious practice, but it's essentially a financial issue, and therefore it may be regulated, versus management is squarely going to have an overlap with these things. So that right can't be subject. And because these rights are about Indo management, society has a lower stake, therefore no social reform. Therefore, the only overlap really becomes about entry, which it's already been dealt with, that as far as Article 17 and entry of depressed classes is concerned, it's in 25(2) specifically carved out. All other forms of entry will be subject to management of your institutions. And Lordship, I just wish to point out that all of the religious and charitable endowment laws that we look at, Lordship, there is a very careful constitutional balance which has been carved out. For instance, the SGPC, the state prescribes the regulation and the norms for regulation, but all members will be Sikh. Therefore, the denomination's right to manage its own affairs is maintained. However, to make sure it's not mismanagement, that is balanced without taking away that right. And Lordship, that is with Hindu endowment boards. That is also, of course, now some provisions are under challenge, but with the Waqf boards also, each community is given that right, and that right is respected even while legislating under 26D. And lastly, Lordship, I want to conclude by saying that, Lordship, I've observed that the internal diversity that has come together on this side, Lordship, is actually phenomenal. Some of us are together on the same side for the first time in this matter, because this is one time when the entire mosaic of our very diverse...
This side, not of this side. So that once you will complete, you are relieved.
Lordship, so...
That's a good thing.
And Lordship, because this is all communities coming together to defend their right to be. And for that, Lordship, I just wish to conclude by quoting Sarshar Sailani when he said, "Chaman mein ikhtilaf-e rango boo se baat banti hai. Hum hi hum hai to kya hum hai, tum hi tum ho to kya tum ho." I'm extremely grateful, Lordship.
Okay, thank you.
If I can just take 5 minutes, my lord, we appear for the Jains.
Now 5 minutes, please.
2 minutes.
Take 5 minutes. Don't.
2 minutes, my lord.
What is the new point you want to raise? Just state one line point.
My lord, it's
For
on
the
the
sake
identity of the tribals and Andaman and Nicobar and how it gets affected.
Don't give the documents time and again. Now, please tell us the point.
Yes, my lord. Just, ma'am,
Unnecessarily wasting time now.
If the identity is not seen in an Indian linguistic term, my lords, their identity gets precluded, it gets devoid. That's my first point. The constitution that we have today is not just for formalized society, but equally for the indigenous society. And this determines the right to self-determine, who worship Prakriti and nature. If the Hindi text is not recognized, my lords, of tribals worshipping a Niyamgiri at various sacred groves and of Prakriti will therefore not be protected. The Indian language, my lords, is rooted in the civilizational understanding of our history, society, and identity. This is an inherent feature of self-determination exercised by we the people, as reflected in the preamble in Article 1, which is India, that is Bharat, and in Article 25 and 26, that has to be construed in a manner where even these isolated tribes, my lords, who do not have legal representation, get a chance to put their rights to and protect their rights. And therefore, we are magnanimous enough in that sense to say that we equally protect their rights. And last but not the least, therefore, it becomes important, my lords, for this honorable court to accept and recognize the fact that we are the largest determinative nation for...
Understood. Thank you.
Just two arguments. Mr. Venugopal had led us on the Jain. 2 minutes, my lords. One of the implications that will happen if, my lords, it has been argued on that side that Article 21 should be interpreted as the highest. But your lords, our argument is twofold, that the same constitutional interpretive expansive principles that apply to 21 also have to apply to 25 and 26. Because one example, for instance, with the Jains, that could get struck down if Article 14 were to apply. My lords, there are entry restrictions in the Jain religion where a female cannot enter the male monk's upashray in various segments, tenets of the Jain religious denominations. Similarly, there are entry restrictions for male lay followers to female nuns who can be initiated into monkhood also. These are, there are various guidelines that the Guruji determines. So if a 14 and 15 principle says that, oh, why are women prohibited from entering the male monks' upashrays, why can they not touch them? Because, for instance, in other certain Therapan Jains, you can't touch a male monk. You have to maintain distance. So 14 and 15 cannot just be brought in within 26. So that is the first argument. The only second argument, your lords, has been argued in terms of essentiality and the importance of essentiality on the other side. My lords, we have already proposed a 5-step proportionality test. My lords, in our rejoinder, we've just given, it's a 1-page table where we have given examples of what the tests are. The first is the law secular or religious? The second is it associated with or a part of religion? Does the equal applicability, does the law apply to all? Then the application of the proportionality test, and then does the law extinguish the practice or hollow out the religion? So we have given various examples. I know my lords is very pressed for time. So if I can just hand over the submissions, it's a 1-page table.
Yes, give to us. Yes, 2 minutes, please.
I did only 1 minute.
Yes, yes.
My lords, I don't have anything to give you rejoinder, but I want to inform your lordship one thing. That one thing is this. One more writ petition is pending before my lord's court. Writ petition is 338 of 2019. 338 of 2019 petitioner is Rahana Fatima versus State of Kerala. Rahana Fatima filed a writ petition before highest court of the country to give protection to her. She is an activist having some kind of Naxalism. She wants to enter into Shabarimala. I am saying from the records. It is, this temple is not like church. Church is also a holy place. That is Aradhanalayam. But temple is deity's house. Deity is juristic person. You can't enter into my house without my permission. You can't come without you, whatever way you want to enter into my house.
All right, that is not.
So my lords, kindly note this writ petition 338 of 2019.
Right now our hands are full.
Yes, my lords.
We'll wait. Yes, Mr. Sharma.
My lords.
Yes. From
A
this
right-
side, we really, it was a treat to hear you, but very free. Like Shraddha argued from this side. Among the young lawyers we are talking, not the seasoned one.
My lords, a right may have facet in more than one articles, like equality. 14 is there, it can also bar untouchability. But to bar untouchability at a higher pedestal, it has been kept at 17. If 17 is deleted, untouchability doesn't come up. Untouchability became an offense in 1955 through an act. Article 17 did not make it an act, untouchability. Then it came into Civil Act in 1976. Hence, my lords, Article 25 also has denomination rights. It has been elevated like Article 17 in 26, but the facet is present in 25. Like, my lords, 17 is present in 14. 15 is also present in 14, 16 is also present in 14. Between 15 and 16, there are various differences like descent, place of birth, All these are not mentioned in 16, but in 15 they are mentioned. In 15 also there is an action against untouchability. When access to temple, wells, and all under 15.2 is enabled, Vilots, through 15.2. So a right may be present in various aspects. In 17, it has been made absolutely at a higher pedestal. Similarly, 26 by eliminating the words not subject to other parts of the provision has also elevated 26 rights to another level. That's the first point, Lord, in short. Second point, most important point, Lord, whether persons and institutions will be covered by 25(1) or not. Milords, a special right which can conflict with other people's right is 28(2). If I give religious instructions in my own institution, that will be barred by 28(1). To protect that right, 28(2) was enacted. There is no judgment on 28(2), Milords. For the first time, my lordships are considering. So to protect the pious purpose of establishing an institution, and it is a religious right, I might do it to gain moksha. Someone create a work to connect with his own God. So, Milords, the pious purpose of attaining moksha results in creation of endowments or trust for public welfare. Even if that land is acquired, the state will give compensation. That compensation will again convert into a pious purpose, because the effect is that I may have pitras, I may have various births, so that punya continues, so that pious purpose of endowment is protected and trust is protected. Why? Because it is a religious right. And where is that religious right? I ask myself, Milords, that is in 25(1). So the rights of institutions are actually rights of individuals. That is why, Milords, in Ayodhya case, Ram Janmabhoomi case, it is said the pious purpose converts into a juristic person, Milords.
Very well.
So, Milords, my whole stress.
Yes, we got the point.
Very well.
You have already argued, Dr. Vivek. One line only, one line.
Yeah, absolutely, Lordship. In addition to what I am argued, I am say only two things, Lordship. First, the principle of proportionality and the harmonious construction have not much effect on the explanation of Article 25 and 26 and the reply of the 7 questions. Second, Lordship, there is a suggestion only. Karl Marx once said, the religion is
Opium.
religion is a opium, and even the intellectuals cannot escape many times of it. So the reply of these 7 questions will be a Magna Carta in the religious freedom in the future history of the India. So that's why to rename the matter from Sabrimala to the religious freedom under Article 25 and 26, it's only request and the suggestion. Grateful, Lords.
Thank you very much. Do you want to say anything? Shamshad, do you want to say?
Lordship, I will take few minutes, my lord.
Only 2 minutes only, please. Huh?
Then probably I'll not be able to say. Then I'll prefer not to say.
Oh,
I can say.
No, tomorrow I'm just.
I'll just.
Mr. Dwivedi,
Your lordship, give
time?
Give me 10 minutes.
Do you also want some time? No, Mr. Gopal Subramaniam, Mr. Dhawan.
As I could be, my lord. Lot of arguments have taken place on the issue of essential religious practice and proportionality. I have also argued on ERP, saying that it is not a good test. Not a good test for the reason because in few contexts, especially Muslim laws related context, it has been applied wrongly. That doesn't mean that it becomes completely wrong test.
But that is not the issue before us.
It is, my lord. It is, my lord. With great respect, it is. With your lordship may permit me. Now, if your lordship is considering to substitute this principle with proportionality test, this will also, in a way, some way or the other, will have some color of getting into the religion and trying to find out what is there so that to find out whether it is excessive or not. So in a way, your lordship will be going into the religious tenets.
Mr. Samshad, you need not to presume what we are going to do or what we will do.
My lord, I can
You only simply state your point.
Yes. My proposition on this issue is that if different religious texts are not looked into the way the religion says, any test that your lordship will give, that will fail, it will fail for some, it will be successful for another. So in the first round, when I argued that when your lordship considers what is the religious tenets in the context of Muslims, it has to be done in a particular way. And I had written in that submission.
Yes,
So that your lordship, if your lordship gets into that, then that will have to be considered so that whatever test comes in.
Your note is quite elaborative. We have briefly seen it.
Second issue is, my lord, in the context of interpretation of 25(2) and 26(b) and 25(1). My lord, the secular activity in 25(2)(a), obviously, whenever government feels that the legislature feels that certain law is needed, they'll come up with some law. That law, if somebody is aggrieved, it'll come before your lordship.
That is what we have already indicated.
Yes,
tentatively.
and that's why I said, requested my lord, that it is relevant, ERP or proportionality or whatever test your lordship propounds. When it comes for challenge before your lordship, that some principle will have to step in so that that secular aspect of legislation is checked, whether it breaches religious provisions, to what extent it breaches. So this issue is very, very, very necessary. And when your lordship is examining that, then at that point, your lordship will see what is the religious tenet. And when when your lordship gets into religious tenets, then the religious tenets have to be seen with the viewpoint of the believer. So that's what I wanted to say, because if that is kept unchecked, then probably Article 25(1) will have no meaning at all. So that is my first submission, my lord. And in that, I'll give few examples, my lord. That's why I said I'll try being brief. Like it has come in the arguments, non-vegetarian food. It is a secular issue for some, it is environmental issue for some, it is health issue for some, it is religious issue for some. Now, if this comes before your lordship has to take a view. Like yoga practices. Yoga practices is, for some it is a health issue, for some it is a religious issue. Now, these are the aspects when it comes before your lordship.
We understand.
Yes, so that is one issue, my lord. And as far as the argument, the submissions that I made about equal entitlement, my lord, this equal entitlement, the focus has been till now that every individual is equally entitled to, and it looks very, very facially, very neutral. Everybody is equally entitled. During the pendency, when the argument is going on from 7th April till today, two incidents have happened. One, in Punjab, there is a act called Jagat Jot Shri Guru's Granth Sahib Satkar Act 2008.
We can't take notice of
Lordship,
this.
I am just citing an example, my lord.
We do not know what
one Guru Granth Sahib is protected. Why not Bhagavad Gita? Why not Bible? Why not Quran? So that is why this issue of majoritarianism comes, because whoever feels that something is required to be protected, the legislature will pass. And at that time, when I come here, that's the will of legislation, but the others have been left out. In that background, my lord, and the second issue, when your lordship was hearing, and I raised this Ismail Farooqi issue, after this, Allahabad High Court has passed an order. I'll just pass it and I'll try closing it, my lord.
So orders like this, Mr. Samshad.
I'll not place it. I'll just read it.
Unless
I'll
it's already
just read it.
challenged before us or it is relied upon.
My lord, the issue is this Ismail Farooqi issue I have placed. Nobody is challenging the Ram Janam Bhoomi judgment, Babri Masjid judgment today. That has become final. Nobody is challenging it. Dr. Dhawan has pointed out just now that Acquisition Act was struck down. But the proposition that has been laid down, saying that mosque is not essential, is hurting every day. And this is one of the example this is a division bench judgment, which says that Ismail Farooqi says that it is, your lordship may permit me.
I have taken notice of this argument when you argued the main case.
My lord.
We have taken notice of this argument. You have raised this argument.
My lord, I have made this argument, but the gravity of this issue is that
your arguments made, my brother Bakshi has clearly put it to the other counsel.
My lord.
Clearly, yes, it majoritarianism, how to construe it from the point of view of the constitution, yes, said. We are quite conscious of it. What you are saying is when you exercise the power testing the decision made in 25
this side.
What are the parameters to be taken into consideration? You are saying we are conscious about it. Maybe a collateral express, malice in law, maybe we can say proportionality, we can not consider relevant materials. There are so many factors we are quite conscious about it. It is not as if it is going to escape the judicial scrutiny. We are quite conscious about it.
So, as far as Ismail Farooqi is concerned, every day there is some or the other judicial proceedings where the mosque issue will go and some judgment will take note of Ismail Farooqi, some will not take Ismail Farooqi, and some way or the other mosque status is vulnerable every day. And if mosque status is vulnerable every day, your lordship, I think that there is no protection of 25(1) to the religion itself. So with this, my lord, because your lordship will permit me to place this submission in 2-3 pages, if your lordship.
No, because they said mosque is not essential. You don't want essential religious practice.
My lord,
suppose they had said mosque is essential, then you would have said keep it.
No, it is not only one example. Last time I made this submission that all the time it has failed except Sayyidna. So I am saying that mosque, the essentiality test, because the reliance which has been placed is on the wrong premise. Certain texts have been taken and that has been understood to be religion and held that this is not essential. And that's why I said that these
don't have that test at all.
Your legal position that earlier judgment is not under review or challenge, that you are right. If there is any order passed subsequently and if somebody is aggrieved by that order, we will examine it on judicial side. That if the form available, will definitely, somebody can be aggrieved by that order of the courts. It happens many a time in different disputes, erroneous orders are passed. We use our correctional jurisdiction.
It was challenged. Honorable 3 judges bench, they rejected by majority, saying that it was in the context of acquisition, whereas that is
a further remedy.
No, my lord, but that's the remedy I am availing today.
No.
That's the remedy I am availing today, my lord.
No, the judgment which you are referring to Allahabad High Court or
that is a different issue that can be challenged again, my lord, because earlier also the same.
And finality, we really, unless there is a form available and form is availed, it's very difficult for us. Otherwise, everything will get reopened. Any other issue which you want to respond?
Deeply obliged, deeply obliged.
One line.
I was on that right of conscience, my lords, and to look at 25 and 26 through that particular prism. Equally important may be, my lord, the boundaries of that particular right of conscience. Because within the individual notions of religion, it will always operate in my personal space. I may have a right. But when I enforce the right to practice, profess, and propagate religion, or the denominational aspect of that very right, what I seek to enforce is the right as practiced by the collective forum. So I look at both that religion as well as denomination as two different attributes of that collective forum. And within that sphere, I may not have a right to enforce within the ambit of 25(1) the right of my notions and then impose it on the collective forum. So that operates as the restrictions. So we have three different boundaries operating as a right of individual, which operates within my personal space. The other two are collective rights, and there both the religion as well as denomination does not include into my right. And as far as the individual is concerned, his right to enforce is that collective right. Otherwise, my lords, the 25 as well as 26 would become meaningless.
Understood, understood. Thank you. Yes, Mr. Father, one line.
Yes, madam. Only 3 lines. My
Your few lines are sometimes without full stop, na?
lord,
That is the problem.
my situation is this, my lord. Lordship is aware about the barbaric story, who are the grandson of the Pandavas, but fighting for the Kauravas. So as far as the Sabrimala is concerned, I am this side. I am saying that like Makkah, Medina, like Jerusalem Church, like 12 Jyotirlingas, like 51 Shaktipeeth, like there are some other temples also, my lord, like Sikh Gurdwara's Golden Temple. This Sabrimala has a distinct sanctity. So as far as this, as far as the my lord, yeah, unique sanctity, yes. As far as my lord 25, 26 is concerned, I am little bit with Mr. Khambata. Why I am saying this? I read my lord entire constitution. The word control is used 25 times, subject to correction. But the word manage is used only once. And that is only 26. None other than that. Similarly, my lord, the most frequently asked questions your lordships are asked, and even today ladyship again asked, why Article 26 is not subject to other provisions of Part 3? Answer is, how many provisions are subject to Part 3? From Article 14 to Article 30, none of the fundamental right is expressly subject to Part 3 except Article 25. There are only three times subject is used, subject to other Part 3, Article 13, Article 25, and 31. So in 14 and 30, only once with 25.
Thank you.
Why? Why I am saying why only 25 has expressly, 26 not? Because only 25 has right to propagate religion. 26 don't have. I have prepared a table. If lordships can only just see my table, it will help lordships. Just please pass on my.
We will see it later on. You can give us.
So I have, my lord, a list of the five types of restrictions. I am saying Article 25 and 26 is the most restricted fundamental rights. The 5 types of restriction are this, my lord. Like 14, 15, 16, 17, etc. impliedly subject to Part 3. Article 21, subject to other impliedly, but subject to procedure established by law. Article 19, reasonable restriction in 19(1), 92, 93, etc. Only 25 has expressly subject to Part 3, none other than. Because 26 is the species of 25. And 25 have 3 fundamental rights. Right to practice, right to profess, and right to propagate. Article 26 has only 2, right to profess and right to propagate. That's why 25 has 3. So expressly Part 3, 26 has only 2. I have given a chart, my lord, if lordships you can see.
We will see. We will look into you. Give to us.
And one more thing, my lord, I used to say. There are 195 countries in the world, my lord. I examined the history, how the countries created. 40 countries created due to religious denominational conflict. Not conflict due to 2 individuals, but 2 individuals. And the latest created countries are, my lord, like lordship can say. I don't want to name. There are 40 countries which have created due to internal disturbance, due to denomination conflict, not due to freedom of religion.
All right.
my submission is visible.
Thank you.
I am only
Right.
requesting, I have some more points, but I cannot probably explain in the. I am only requesting lordships, please go through my rejoinder and my written submission. I have totally distinct ideas on the, not this side, not side.
You are partly this side, partly this side.
Yes, I am in the position of barbaric. Khatu Shyam, Hare ka Sahara, Baba Shyam Hamara.
Very good, very good, very good. Now, please, if there is anything new, please one liner.
Two lines. This is again regarding that.
Yes, please.
This is again regarding that
Please speak.
tribal. Lordship, at least for the purpose of statutory protections of the scheduled tribe, Adivasis are considered as the Hindus in the Protection of Civil Rights Act 1955. So hence, they are one of the denomination of Hindus. Can
You have
we
already
note this
argued
point? And one more point.
Already argued this and
No,
nobody has
this
argued
point-
against
This point I didn't argue. And another one is of how they differentiate this. Adivasis or tribes who are the Prakriti Pujak, and whereas the non-tribes who are temple traditions. These two traditions which differ tribes as well as the non-tribes. And the third point is tribal rights are not just individual rights. It's a community rights. That's all.
Thank you very much. Thank you. Madam, yes,
Only 1 minute.
Yes.
Look, there is an emotional argument by one of the
Yeah,
petitioners.
you spoke about them. Straight come to the point.
Matter saying that she's a devotee, but she's a believer. The thing is that see, they are complete strangers to the religious practice that we are following in Kerala. In Kerala, whenever a girl child is there in the family of a devotee, they bring the girl child to the Sabrimala temple as many as possible before she attains the age of 10. So it's a unique temple. Only to address that point.
Thank you very much. Now, you will have to bear with us and we'll hear both of you, all three of you tomorrow morning. And then we'll, where is Mr. Parmeshwar? Approximate how much time he wants?